Good afternoon, everyone.
Good afternoon, Judge.
Good afternoon.
Give everybody a minute to get turned on and all that good stuff.
Well, the judge is John Christie. I'm still struggling with my phone to get the video to work, but I am working diligently at it.
No problem. I hear you, Mr. Christie.
Yes.
Okay, so I only have two things on my calendar, and I know there are a lot of lawyers involved in these various cases, so it may be that all of you are here for that, but let me make sure we're all in the right place and I haven't excused anyone that doesn't need to appear so that you can get on your way. I have a status conference to follow up on an interlocutory injunction that I entered back in June in the Throttlebox Entertainment versus Blair Richardson. I see Ms. Brown. I see Ms. Richardson. And to my knowledge, Ms. Richardson has not retained other counsel. So other than perhaps, I also see Mr. Wolf. So sounds like those are the principal key players in that.
That's
Ms.
correct.
Brown, anybody else that you were expecting here just for y'all's matter?
No, Your Honor, we do have a court reporter present for today to take anything down, just
Okay,
so we can
thank you.
capture any directive correctly.
Okay, thank you, Mr. Carroll. And I will let you know when I'm ready to start. I'll formally call the case just so you'll know that that's when it's ready to take down.
Thank you.
Then the second matter I have is a motion, well, dueling motions for attorney's fees in the matter of Scott Jones versus Jennifer Cummings and Kellum Investments. Who do I have here on behalf of Mr. Jones?
Ally Jett, Your Honor.
Okay. And who do I have here on behalf of Jennifer Cummings?
Bo Howard, Judge.
Okay. And do I have anyone here on behalf of Kellum? Apparently not. So I know I can account for a few, just to let you guys know, you lawyers. I have some interns here with me this summer who are observing and hope to see some good lawyering. So I have Neha Nyack, who is actually just graduated from high school, getting ready to go to college, but she thinks she wants to be a lawyer, so let's not change her mind. And then I also have James Robertson and Adina Begg and Isabel Rogers, who are rising second-year law students. So again, let's not change their minds.
Your
Now,
Honor, real quick.
yes, sir, Mr. Ayub.
I would say that also Carolina Bryan and I are here on behalf of John Robinson and his law firm, Greg Blazer, that were also, I think, named in a motion for attorney fees by Mr. Howard as well.
Okay, excellent.
Just to be clear on that, we're on the.
Thank you. I was getting to y'all because I
Side,
recognize you and know
we
you, but I
represent-
wasn't sure why you were there.
Yes, so that's
Mr.
why
Christie?
we're here. Wanted to make sure you understood why we were here as well.
Thank you, Mr. Ayub and Ms. Bryant. And Mr. Christie?
Yes, Your Honor.
What do I have the pleasure?
I'm here for Mr. Robinson and his law firm.
Okay.
Whoops. So I can, you'll see I'm on my wife's laptop here. So, so I can
That's
turn
fine.
this phone off right now so I don't have an echo there.
Technology is grand.
Yes.
So I have both matters set at 2:00. I can tell you right now, it's going to take me, I'm going to guess 20 minutes ish to 30 minutes ish, maybe less, to address the Throttlebox matter. And then I will, so those of you who are here for, that are not here for that matter, if you're free to observe, you're also free to turn off your video and audio and wait until I call it. It'll probably be closer to 2:20, 2:30. And we'll take that matter up when we're ready. Okay.
Thank you, Your Honor.
Thank you. Okay. So, oh, wait, one more thing. For the attorney's fees matter, Mr. Howard and Ms. Jett, do y'all have a court reporter?
I do not, Your Honor.
I did get a court reporter, Judge. I think I saw somebody on from Esquire. I think
Is that
Brandon
Mr. Roberts? Okay.
Yes,
So, Mr. Roberts, I will promise I'll call the case when I'm ready to take it up and you'll know when to start taking down. Just wanted to check and make sure. And again, you may all turn off now. Okay. Let's see. Mr. Court Reporter. I am now Mr. Carroll. This is going to be a temporary interlocutory injunctive hearing in the matter of Throttlebox Entertainment versus Blair Richardson, case number 25 CV 007060. I'll note for the record that Ms. Brown is here on behalf of Throttlebox Entertainment, and that Blair Richardson is also present at the hearing, but she continues as pro se, does not currently have an attorney. And that also present at the hearing is David Wolf, who is, I think, the client representative, but also is an attorney, is my understanding. So what let me start by letting y'all know a couple of things. So obviously we had a hearing previously. I entered an order. I was a little concerned, Ms. Brown, you filed something today that recited that I had not entered an order on the original, and I did. It's document number 16 in my record. It indicates that it's an order granting in part and denying in part plaintiff's request for temporary restraining order.
Okay, I did not receive that.
Okay, we will check on it. There's been an issue. I don't even know why the option exists that you would e-file and not e-file and serve, but there's been an issue recently with Georgia e-file where for some reason it's defaulting to e-file only and not e-file and serve. So that perhaps is why. I don't know. I'll have Mr. Freehoff check on it. But I did enter an order. It was essentially, I mean, in large part, it was what you had presented. I edited the one that you had sent to me as a proposed order at my request. I changed a little bit of the language to reflect what I believed was, closer to what my ruling was. But that is docket number 16. It was entered on June the 23rd. And in that order,
Your Honor, I don't mean to interrupt you, but can we address the court reporter and kind of like last time? I do have a court reporter here. I don't know if Miss Richardson wants to share takedown. I didn't have those cases handy last time, but I do this time. And if she does not wish to share, I would ask the court to enter an order indicating, after affirmatively confirming with her on the record, if she doesn't want to share, that she will not have access to the transcript.
Ms. Richardson, do you wish to share and take down?
No, ma'am.
Okay. So, Mr. Carroll, just so that the record is clear, we had the same conversation at the prior hearing. Ms. Richardson has declined to share in the takedown. And so, Ms. Brown has requested on behalf of her client that Ms. Richardson be not allowed to have a copy of the transcript, having not participated in takedown.
Thank you.
And so I will direct that be the case. Thank you, Ms. Brown. So the order that I entered, it was nunc-pro-tunct back to the 4th day of June, since that was the day of our hearing. And it said that my order was to remain in place for 30 days until Monday, July the 7th, at which time it would expire according to its terms unless it was extended. And so the purpose of today's hearing was to determine sort of the status of what's going on with the parties, because obviously the order required that the parties make some good faith effort to discuss the issues and move forward. And to determine if I was going to continue the hearing, or excuse me, the injunctive relief in some form. Now I am aware that the parties have sent a number of things to Mr. Freehoff, my staff attorney. It is not yet in the record, but I believe that Throttlebox has filed a new, having read it, it looks a lot like sort of a renewed motion or a motion to continue the protections that were previously in place. That is pending, although it is not in the docket yet. I have received a copy of it. Presumably, Ms. Richardson was copied on that by email. And then Ms. Richardson has sent to the court 2 documents that I don't know if they have been filed, Ms. Richardson. And I will tell you that if they've been attempted to be filed, the reason I mention that is that they very well may be rejected by the clerk because they don't have a case caption on them. They are appropriately characterized as letters, not a legal pleading. But sure. In any event, they have been provided to me, so I am aware of them. And one of them is a sort of restatement of the concerns that Ms. Blair wishes to assert, that she continues to be pro se, that she is appearing specially, and that some additional allegation of, alleged harassment or interference with other parties. And again, Ms. Richardson, I've told you every time we've met, I can't give you legal advice. You should get a lawyer. Although you're entitled to represent yourself, I will tell you, frankly, that's always a bad idea. But I can't give you legal advice, but I can tell you that the types of things that you are asserting, they may be evidence, they may be the basis for a counterclaim. I don't know, but they're not appropriately before the court currently because they haven't been filed. They're not in the form of a pleading, and you're only appearing specially currently.
Sure.
Also, I am aware, just to make sure the record is clear, that Ms. Richardson has not yet been served, although one of her submissions to the court acknowledged that she is aware that the court on June the 23rd entered an order of service by publication. And that matter is pending currently in terms of the time running for the matter to actually be published and for the deadline for a response to be filed based on the date of the order of publication. So that's sort of where we are. Ms. Brown, can you tell me if I have correctly characterized the filing that you submitted as an effort to continue in place some sort of interlocutory relief, even if maybe you have additional or different requests now in terms of the nature of that relief?
That's correct, Your Honor. And again, I haven't seen the order, but yes, the spirit of it is to continue an interlocutory injunction. I did mention in that motion, I now have, after not successfully setting mediation through Ms. Richardson's cooperation, I have reserved Dino Brogdon Sr. at Henning Mediation on August 5th, which I don't know if that coordinates with the dates there of the entered order, within 30 days. We'd have to discuss that. But I think he would be an excellent fit to mediate this case because, number one, he was a former Fulton County judge. Number two, he has areas of expertise in many areas, including complex business litigation and entertainment law. So
I've actually mediated a couple of complex litigation entertainment law cases, which, Brogdon as the mediator before I was a judge. So I would agree with that assessment, Ms. Brown.
Excellent. So, but yes, Your Honor, the short answer is we are asking for an interlocutory injunction. I do want to address the amended relief because I haven't seen your order, and I apologize for that. I did get the order for publication. I didn't get the other, and I regret that I didn't go into the docket and go digging before today. I just didn't think about it. The order for publication, of course, that's all pending and in motion, and we're working that plan. But the amended order that we are seeking at this point is to actually ask Ms. Richardson, or for you to direct Ms. Richardson to take all of prior posts down. She's indicated to me in an email since we were here on June 4th that she really can't go back and amend prior posts. And I've also clarified with Throttlebox that they consider it not a mitigation of damages to be put together on posts with Ms. Richardson, and they don't wish to be there. So they consider it mitigating their damages to keep things totally separate. So we believe, and especially I think Ms. Richardson's most recent letters to the court confirm that really the only relief here, there is no monetary relief available at law, is to take those down and to have both parties refrain absolutely from any posting of REM and any, all the language with the alienation and nobody attempts to copyright. I mean, all of this is TBD. But in the interim, we have this interlocutory injunction that continues where nobody can do any posting of REM or alienation of those rights. So all that language is in the motion that I put in today. So that's the nature of the modification, Your Honor.
Okay. Before I hear from Ms. Richardson, I will just add to that in terms of, Mr. Freehoff did just a moment ago while we were discussing it, email to both parties a copy of the order. So y'all should have that, although I imagine it might be difficult for you to multitask, Ms. Brown, while you're trying to talk to me, but also read what the order says. I start by saying that because one of the points that you just made is one of the things that became a little bit of a sticking point when I was attempting to craft an order, is that during the hearing, the request, essentially, the objection that, as I understood it, that Throttlebox was making in the original hearing was that Ms. Richardson was out there marketing and publicizing this film and claiming credit and not giving any credit to Throttlebox, who claims that it owns or it has some ownership interest, whole or otherwise, in this in the film. And so then when you sent me your proposed order, you did share with me that your client did have that concern, right? That they didn't believe that being conjoined with Blair Richardson, or in her professional name, was a mitigation of damages, that it was not, it was unhelpful. But it was hard for me to reconcile that with the complaint of, we don't want to be associated with her, but also she can't claim credit for this thing that we own. And I think everybody should recall that at the hearing, my primary issue was I felt that prohibiting the marketing of the property was essentially an effort to sort of devalue the asset that was in dispute, and that didn't seem to serve anyone's interests. Even if Throttlebox doesn't wish to be associated with it, ultimately Throttlebox is saying we own it. And so the more valuable it becomes, the more damages Throttlebox would be entitled to if they're successful in vindicating that interest. I say all that to say that I certainly, we can discuss what to do about posts and credit. But currently the order that is entered says that everybody agreed that, Ms. Richardson is prohibited from alienating the property, selling it, loaning it, encumbering it in any way. The next two related to social media posts, and the court specifically allowed Ms. Richardson to market, advertise, and publicize the film, but that any such activity had to include attribution or credit to plaintiff. And that included social media posts, posters, festival participation. The third item is the one you're talking about now, which is that looking backwards to prior posts. And based on, again, the original request, which was that plaintiff objected to not being included or attributed as owning or having some interest in that property, the court required that as to prior publications, that the defendant had to make reasonable good faith efforts to identify and update posts or publications and to include attribution or equal credit, and that none of them could be destroyed or deleted. They had to all be preserved. And then I ordered the parties to mediate ownership interest in the story and rights to that film on at least a temporary plan before expiration of this order. The order expires on Monday, but it does sound as if the parties have agreed to, or at least attempted to, in good faith, that the plaintiff has located a mediator and has found an available date that the parties could mediate the case. So as a background, Ms. Brown, do you wish to add anything to that after my ramblings, after you presented, before I call on Ms. Richardson to respond?
Well, and it wasn't rambling at all, Judge. I mean, it was clarifying what you did, and I understand it. And I would say that Throttlebox has further refined the need and the request since we were here the first time, based on things that have happened. I mean, while I don't want prior posts destroyed because they're evidence, Ms. Richardson has indicated to me after the June 4th appearance that she can't necessarily go back and edit prior posts. I might ask for my Throttlebox representative's input. I'm not sure if you probably don't want testimony today, but Mr. Wolf, as an attorney, might weigh in that regard. But I want to, what I have clarified since we were here last is that there can be no joint endeavor with these two parties because of the dispute. I will say that despite my efforts to try to get mediation done before today, I have not received cooperation from the other side in that regard. I did set up a phone call with Ms. Richardson yesterday. We had it. I got the dates from her that she could mediate. I think I mentioned this in my motion that was filed this morning. And then I went fast to work on trying to get that done. I didn't get that level of cooperation on the other side because my effort was, we didn't get the mediation done before we reported today. Let's at least be able to report to the judge that we have a date. And so I have, based on the dates Ms. Richardson gave me yesterday, I have scheduled that with Gino Brogdon. So I would ask the court specifically to order us to go with him on that date for all those reasons. I'm not sure what Ms. Richardson's position on that choice is going to be today, because the way we left it yesterday was she was going to research the neutrals. I told her how to go on the website and look at the people and find people she thought would be a fit and let me know. And that's sort of where things were left with her. So, but we would ask for the extension. I think the extension is warranted, not only until we mediate, but until further order of the court, because we're not realistically going to be able to report back to you after mediation. I'm not super optimistic that we're going to get all of these issues settled on a temporary basis based on what Ms. Richardson has represented to me. So our ask would be until further order. I think that is it. I do want to point out that the things, despite them not being filed into the record, the letters that were sent to the court are riddled with hearsay and not reliable and admissible evidence for anything that the court might consider for today. And I think Ms. Richardson is on some level creating a special appearance, saying she hasn't been served, and she's showing up, and she's now, and has been somewhat addressing the merits of the case. And it's, I'm going through the motions with the service, Your Honor, but Ms. Richardson, I think, is being a tad disingenuous with the system and what we're trying to do. And I would like to start addressing the case on the merits, and have been endeavoring to do that since June 4th, and we've not received that level of cooperation. So
Okay.
that's the essence of the extension request.
Thank you, Ms. Brown. Ms. Richardson,
Yes, ma'am.
now is your opportunity to respond to whatever issues you think are important for the court to be aware of in terms of what Ms. Brown has said, or the status of the case currently. And the main request, which is that the court extend the current injunctive order that's in place.
Thank you, Your Honor. First, I want to address disingenuousness. I'm happy to provide work receipts or bank receipts. I just simply do not have that much money.
Ms. Richardson, let me stop you there. You don't need to explain that to me. I'm willing to accept at face value that somewhere between $5,000 and $15,000 is a lot of money to pay an attorney to represent you. I understand that. But it is an unfortunate reality that the case is the case, and whether you want to or not, you're going to have to either retain counsel or proceed on your own, because you've been sued. And if you wish to defend yourself, you're going to have to engage in that at some point. I understood Ms. Brown's point about disingenuous. It's not about the fact that you don't have a lawyer, but about the service issue. And even that, you don't need to defend yourself. As far as I'm concerned, I will simply point out what I think I pointed out to you last time, which is service is not a game, right? Ultimately, it's just the procedural way that we get a matter before the court. Number one. Number two, though, is that Ms. Brown has correctly pointed out, and you seem to be aware in one of the filings you sent me, that I have already entered an order of service by publication. And again, I can't give you legal advice, but I can tell you that legally, that order of service by publication, having been entered on the 23rd day of June, if you go look at the law or ask an attorney, they'll probably tell you that your answer is due on or before 60 days from the date of that order. And if you don't file an answer or some response, then you run the risk of being held in default. And I'm sure that Ms. Brown will pursue that if it comes to that. And so I will also say that I am aware that Ms. Brown, she has documented her file to indicate that even though it wasn't a formal request to waive service under OCGA 911-4, she has sent a written request for you to acknowledge service, and you've not done so. I can't make you accept service. That's not how it works. I can't order you to do it. But at some point, Ms. Brown is pursuing all available avenues to her. And at some point, legally, it is likely that it will be deemed that you have been served. And if you do not attempt to defend yourself either on your own or through an attorney, then you run the risk of having a default judgment entered against you. Again, I'm not saying that will happen. I'm saying that is something that may happen in this case, and that you should be aware of that, Ms. Richardson.
Yes, Your Honor. And I do apologize for being difficult in any way.
You've not been difficult. You've been very respectful. I don't have any problem with that in the courtroom. It's just, virtually, as it were. It's just the service issue it's continued to arise. Please go ahead, Ms. Richardson.
Yes, ma'am. With all that being said, just to address the injunction, I was more than willing to honor what I said last time about crediting the plaintiff however he thought that should be, and then getting that email saying they didn't want that. So I kind of just held off because I'm genuinely confused what exactly they want. As far as mediation, I'm happy to do that. The only reason I didn't schedule it yesterday was because upon further research, because I'm basically going to law school via Google at this moment, I don't have very much money. I'm sorry to repeat that again, but I don't know who pays for the mediation. And I just need to know like the terms a little bit clearer before I agree. Plus, I'm working multiple full-time jobs. Just I have to coordinate with all those things, which I did explain to Ms. Brown on the phone call. So as far as everything in a nutshell, I'm trying my best in good faith to do everything that I think I'm supposed to do while also trying to defend myself. I've started gathering documents and all that stuff. I know we haven't gotten to that phase in the case, but I'm actively trying to seek counsel and I will continue to do so until that's done. And then, as far as the social media stuff, I do that as a full-time job. Some of the earlier posts are able to be changed on some of the platforms like Instagram, Twitter, TikTok, that kind of stuff. They usually have like a 14-day limit. Most of these posts are from 2.5 years ago. So unfortunately, even if I wanted to, I can't change the bio of the post. And then I do want to reiterate, all of these posts are from my personal social media platforms. Me as a writer and director. So it's not like I'm posting these things on, a specific RIM page or anything like that, or a Thought page. It's just for me to represent and promote me as a writer and director. So I just wanted to reiterate that. Beyond everything else, it sounds like the things that I sent in weren't correct, but I do just want to address I have been very calm and respectful of everything from the other side. It was brought to my attention unprovoked by many people, at least 25 different people in succession, that the plaintiff, Barrett Wolf.
Objection, Your Honor. I believe she's getting into inadmissible and unreliable hearsay evidence at this point.
I have physical evidence of it
Well,
if the
hang
court
on.
wants.
So hearsay means it happened outside of the courtroom. And so it doesn't matter if it's written down or if it's something somebody said, it's still hearsay. This is an informal argument, so it probably doesn't matter. But Ms. Richardson, I'm aware of those allegations because I've seen the letter that you've submitted to the court. So I'm aware of it and we'll just move on from here. Ms. Brown's objection is she's not wrong that that would be hearsay. But again, this is an argument, not an evidentiary hearing, and we can move on. Go ahead, Ms. Richardson.
Yes, Your Honor. Apologies. So I guess I don't really have much else to say other than I continue to do everything in good faith, and I'm more than willing to cooperate. And Throttle Box does not own RIM.
Okay. So I have a couple of questions, Ms. Richardson, first for you. One is to answer your question and then ask one, which is that generally speaking, mediation most of the time is the cost of a mediation is split between the parties. That's something that can be negotiated just like anything else in a lawsuit. And so that's something that you would need to talk with Ms. Brown about in terms of the anticipated cost and the anticipated cost sharing of that process. So I can't answer that question for you. However, I can tell you that I have ordered the parties to mediate. So my second question is, regardless of the cost breakdown, it sounds from Ms. Brown as if y'all had tentatively discussed the possibility of some dates that might work. And I want to say, I thought I heard Ms. Brown say August, sometime in early August. Is that right, Ms. Richardson?
Yes, August 5th, I think, is believed the
Okay.
day I could get to Atlanta.
Okay. And so my question is, in compliance with my order, are you able, understanding that that cost issue is going to be a thing and that you need to agree to whoever you might choose as a mediator, but that tentatively y'all have set aside August the 5th as a date that you are going to attempt a mediation, assuming that you can work out cost and mediator issues. Is that correct, Ms. Richardson?
Yes, Your Honor.
Okay. To be clear, Just want to make clear, I don't expect that anybody will not comply with my order, but if you don't, if everybody agrees to have a mediation on August the 5th, and then you don't, I would not be surprised if Ms. Brown then argued that you had, failed to comply with the court order and were in contempt, and then asked me for sanctions that she would argue flow from that. So I just want to let you know. Ms. Brown, I think it would be helpful to know, to clarify that email confusion that Ms. Richardson says she had, and that admittedly I had as well after the hearing, which is what to do about if the court's position from a preliminary standpoint is that it is not a reasonable remedy from an interlocutory perspective to order her to not market this product, right? That this unique asset. And that the court is not going to prohibit her from marketing it or advertising it. And so the compromise that the court tried to craft was, okay, but if you're going to market it, you have to give credit to Throttlebox in terms of, a line in whatever email. Is that something that Throttlebox no longer wants in terms of I should get rid of that paragraph, or understanding that the premise of this is I'm not going to change the order, that she is still allowed to continue marketing it and advertising it so long as she does not alienate the product without notice well, she can't. So
I'll try to answer your question. And I did just skim the order on the phone while Ms. Richardson was speaking. Throttlebox does not want to be associated with Ms. Richardson on these posts. Throttlebox's position, as I've now clarified with them, is that their best way to mitigate damages is for all of that to come down, any prior post to come down. And I'm gathering the court's not inclined to order that, but that is the ask of Throttlebox, is that all prior posts of Ms. Richardson come down and nothing further be posted, at least until the parties can get to mediation. I think it would be reasonable to try to revisit that issue there so that Throttlebox can explain, with the presence of a neutral, to Ms. Richardson why a shared credit is not going to be reasonable in this situation, and not going to be a remedy that they can cooperate with or accept. I mean, they feel like it would further damage to them, and that's something that we would be prepared to explain thoroughly in a mediation setting.
Okay.
So that is the ask, Your Honor. I also, before my time is up, there's a case I did mention in the motion that I think is important as the court considers an interlocutory order today, and I understand there's already been one entered, but as far as an extension, Consortium Management Company versus Mutual America Corp., 246 Georgia 324. It's a 1980 case, still good law. No requirement of personal service prior to the issuance of an interlocutory injunction. Notice to the adverse party is all that is required. So, and we're relying on the evidence that we put in at the last appearance. And I would also ask that, since service is still an issue and it's ongoing, that while we have Ms. Richardson here, that the court inquire of her current address on the record, and that she be required to provide that.
Ms. Richardson?
Yes, ma'am.
I believe I think there is some understanding that has developed in this case that you are no longer residing in Georgia and that you currently reside outside the state. Is that correct?
Yes, Your Honor.
Do you have a residence address in California? And if so, will you please share it with the court?
I do not live in California.
Okay, that was my fault. Where are you living, and can you please provide the parties, including the court, with your address?
So I can give you an address, but I am not currently there, and I don't know the next time I will be there. I work on the road. So I can give you, again, I can give you an address, but I won't be there.
Well, that will be Ms. Brown's issue, not mine. What I've asked you for is to provide the court with an address that you currently consider to be your legal address, where perhaps you're registered to vote, or you have a driver's license address, or you receive mail, anything like that. That is what I'm asking for. Please provide me with that address.
Sure. It's my father's address, so I can give that to you. All my things are there.
Go ahead.
I'm sorry, Your Honor. I'm looking it up. Um, can I text him?
I'm sorry?
Am I allowed to text him to get the address?
You don't know where you currently reside and what address you give to people to mail things to you? I mean, granted, I get that young people are much less tied to a physical mailing address than people my age, but that does seem a little unlikely.
Yeah, I
How long
mean,
has your father been residing at that address?
I just don't see him very often. I can give you my grandmother's address.
So, Ms. Richardson, I understand that you are on the road a lot, but what I asked for was your legal address.
Sure. I don't currently have one, but I'll give you my grandmother's. It's 537 Lake Doe Boulevard, Apopka, Florida. 32703.
Can I ask her to spell the street?
Lake Doe, Lakedoe.
537?
Yes, Miss Brown.
Thank you.
And I do apologize. I'm a full-time independent filmmaker and content creator. I live on the road.
I understand, but most people are, in fairness, Mr. Richardson, most people, even people who are out and about and don't have a settled address, they do still have a legal address that they use when they need a mailing address, or a legal address, say, for example, to register to vote or to have a driver's license or to do all the many things that we need to have a registered address for. In any event, I have asked you to provide me with a legal address, a legal residence address, and you have provided me with one. And so we will move on from that for now.
Yes, ma'am.
What I do want to get a final issue. So I am inclined to continue the interlocutory injunction, that the primary part of which will be to prohibit Ms. Richardson from alienating the asset in any way, right? You can't sell it, you can't encumber it, you can't do anything like that while this matter is pending. The additional limitations that the court had previously placed, I believe that the reason the court entered both of those orders is that I was not at the time inclined to order her to refrain from marketing the product or to take down prior posts, only that she had to maintain them. And that the compromise was the court thought it was reasonable, and also Ms. Richardson offered it. Well, I'll give them credit on emails when I'm posting. And then since then, it's my understanding, Ms. Brown, that your client does not wish to be associated. So all of that is a long factual background way of asking this question, which is items 2 and 3 in my order. Do you wish me to remove them? Right. So one of them was item 2 is that if she posts anything else, she needs to include Throttlebox. It sounds as if your client does not wish to be associated and that the court should not include the restriction that she has to give credit to Throttlebox if she posts or markets the product REM in any way.
Well, the ask for item 2 would be that the court order her not to post and not, so are you?
Right, but I'm not going to do that. Like I said, the preface to that is I'd already considered that in the last hearing, and I don't think it's a reasonable request under the circumstances, because I think it has the effect of potentially actively devaluing the asset that's in dispute. And so I'm not going to order her to not market or advertise the film. But the compromise at the time, and I think it still holds, is, but I can require that she give you credit, is what currently is there. But it sounds as if your client does not wish to be associated with Ms. Richardson. And so my question is, do you want me to remove item number 2?
I'm actually trying to confirm that, Your Honor, but yes, I believe we want you to remove number 2.
Okay, and then number 3 is regarding any prior posts that Ms. Richardson was supposed to make reasonable good faith efforts to identify them, and also to update them to include attribution. And so it seems to me that number 3 should still continue in effect, because she does need to make reasonable good faith efforts to identify any posts where she was talking about the project REM. And she also needs to maintain them, preserve them, and make sure that none of them are deleted or destroyed. It seems as if we can simply get rid of the part that says that she has to update them to reflect equal credit or attribution. And then as to item 4, which is that the parties will mediate, what I would likely do is if the parties have a tentative mediation date of August the 5th, that I would continue this at that point. The time for Miss Richardson to have responded to the complaint will likely have occurred. If I were to set something in September of 2025. We would at that point know where we were procedurally. The parties would have accomplished a mediation, and we would know what Ms. Richardson's procedural involvement is going to be in the case in terms of the time for her to answer will have come and gone, and we'll know if she has answered or filed responsive pleadings of any type at that point. So that's what I'm inclined today to do, is to continue but modify the interlocutory relief that I previously granted, to have it continue in effect through the beginning of September. I'm looking at a calendar just to make sure I've got my dates right. What I would probably do is have it continue in effect through Friday, September the 5th. And with the expectation that the parties are going to mediate and that they've agreed to a tentative mediation date of August the 5th of 2025. That is the intention of the court. Ms. Richardson, do you have questions, objections, et cetera? Understanding that I'm pretty sure that's what I'm going to do. But I want you to have an opportunity to say your piece, and then I'll also call on Ms. Brown to have a similar opportunity to respond. Ms. Richardson?
I just want to apologize for the frustration I've caused the the court for not having an attorney. And I don't really have any questions. Need to mediate, get an attorney. Happy to do whatever the order says.
Okay, thank you, Ms. Richardson. Ms. Brown?
2 things. Would you be inclined in your order to direct us to mediate as I've reserved with Judge Brogdon Sr.? Because I do have that on hold, and what I don't want to run into is we're trying to find somebody to cover an August 5 date. I mean, I've literally reserved that with Henning at this point.
I don't have a problem, but if I did, it would probably, I mean, here's my concern. I think Gino Brogdon is a very good mediator and would be he's knowledgeable and would be a good fit for the parties. But it's not my choice. And so I think Ms. Richardson, in fairness, should have an opportunity to say, I would rather use a different person, but absent some specific objection or to former Judge Brogdon or a specific request to use someone else, my intended order language is going to say that the parties have tentatively agreed to mediate on August the 5th with Henning mediation, and then perhaps a footnote that potentially it will be with Judge Brogdon. I'm not really sure what I'll do in that regard. What I'm trying to avoid, Ms. Richardson, in fairness to Ms. Brown, is I think what she's made is a reasonable request, but you're entitled to either agree or object. What I'm trying to avoid is the gamesmanship that sometimes arises if you decide, you know what, on August the 1st, I don't want to mediate with Mr. Brogdon, in which case y'all aren't able to comply with my court order because I've ordered, you'll never get another mediator in that short of a time period. But I do want you to have a reasonable opportunity to suggest someone else or object. What are your thoughts, Ms. Richardson?
I would love to, again, new process, trying to figure it out. I would love to look at him and other options, I will do it as quickly as possible. I don't intend to wait till the last minute.
Okay. Ms. Brown, what was your second issue?
Your Honor, may I have 2 seconds?
Sure.
And my second issue, if you could hold that thought, if you could just give me one moment.
Of course.
Excuse me, Judge. Judge, can you hear me?
I can now. Yes, sir.
Thank you. I'm actually out of the country. I'm in the middle of the Baltic Sea and I'm having difficulty communicating with Chris. I'm trying to call her, but I don't, and text her, but I don't have a connection. I'm trying to send her an email. So if you could just give us a moment, I'd appreciate it. I'm trying to email with her.
Yeah, that's not a problem. Thank you, Mr. Wolf. I'm happy
Yes,
to
ma'am.
accommodate.
One last question, Judge. Do you have one of those breakout rooms that I can talk to Chris in? Is that a possibility?
It absolutely is. I'm happy to take you just a few minute break. Mr. Freehoff, can you hear me, sir?
Yes, I can, Judge.
Hey, can you create a breakout room for Ms. Brown and Mr. Wolf, please, so that they can speak before we conclude that matter?
Yes, let me get that set up.
Okay. I
Thank you,
think what'll
Judge.
happen, Ms. Brown and Mr. Wolf, is that you'll get a note on your screen that says you have to push a button to go into the breakout room.
That's
But
right.
that should be set up for you here in just a moment, and we will await your return.
Thank you.
Thank you, Judge.
We just
Sorry
need a
for-
minute. Thank you.
That's fine. Thank you. And Ms. Blair, Ms. Richardson, it is 2:52. Just so they're not super rushed and we're all not sitting here staring at each other in silence, I'll just say we're going to take a break until 3 o'clock. And if you're not back by then, that's fine. We'll wait until you return, Ms. Brown and Mr. Wolf. Okay?
Yes, Your Honor.
Ms. Brown, were you and Mr. Wolf able to communicate?
Yes, thank you, Your Honor, and I appreciate the court's indulgence with that. We actually have an adjustment in light of your expressed order inclination. We do want to ask you to revise our ask about numbers 2 and 3.
Yes, ma'am.
So we would ask that any post that Ms. Richardson puts up include in the post a Throttle Box Entertainment LLC production or a Throttle Box Entertainment production, specifically those words. And that would be in every post, future, and any that she goes back and modifies that she can. And then we would also ask that she be directed to unblock from all the social media, Throttlebox and David Wolf and Barrett Wolf, so that we can monitor what's being put up. And then lastly, that she be required to send me as counsel for Throttlebox notice of any posting so that we can monitor what's being done. Because right now we're blocked. We have no way to monitor whether or not she's including us.
Okay. So let me preface anything I'm about to say with I am very much not fluent in the language of social media. And so anything I say that sounds really dumb, just assume that I'm somebody's grandma and don't use social media. But based on what I generally understand from having teenagers, it does seem to me not an unreasonable request to unblock them so that they can see what's being posted. With the only caveat that if I do require that, Ms. Richardson, that I would also require that no one engage in commentary or communication, because I would assume, whether it's valid or not, I would assume, Ms. Richardson, that is part of why it was blocked. Was blocked was to avoid communication, and so I think it is reasonable, Ms. Brown request, to have Ms. Richardson and whatever platforms she has to unblock so that the posts regarding that property REM are visible and that you can see them, but it would contain a similar requirement that the parties should not engage in any communication associated with it through social media channels.
Understood.
Ms. Richardson?
I just wanted to clarify the reason that those specific parties, the Wolves, have been blocked is because of the ongoing communication to outside people. And so it's honestly a measure of protecting myself. So I will do it. I am quite concerned, however. So.
Okay. Well, if the court includes a proviso that the parties should not be engaging in communication using social media channels regarding the product, then I think that should cut off, that should mitigate that concern, Ms. Richardson. And if the parties are not adhering to that, then I'm assuming someone will bring it to my attention. Ms. Brown? Oh, I'm sorry. Yes, Ms. Richardson,
I'm sorry, Your Honor. I was just gonna say, it's not necessarily the product, it's me personally and my reputation in the industry that is being, perpetuated, these negative connotations associated with my name. So that's what I'm more concerned about.
Okay. Well, I will let you know that issue is not in front of me currently, because as I pointed out to you, the letter that you have sent that outlines that concern. I don't know if you attempted to file it with the court or if you only emailed it to my office. If you only emailed it to my office, then just so you understand, it is not a filing. It is not going to be an official record of the court's file. But also, if you attempt to file it, they're probably going to tell you that it doesn't have a case caption on it. And thirdly, again, I cannot give you legal advice, but much of what you're saying are things that you would say in defense of yourself, and you aren't currently in a posture of defending yourself because you've not been served yet and you've not answered the complaint yet. So you will need to discuss those issues with an attorney and decide you know, what that means to you and what action you choose to take about it.
Completely understand.
Ms. Brown, anything else?
The only other thing was my ask about Ms. Richardson having to notify me if she posts, because I really have no way of monitoring what form she's posting in and whether or not she's abiding by your directive as you just stated it. If she doesn't, then tell me I've posted it here, so we should know.
I'm concerned that that's not very practical and that it will have the effect of allowing you to police what she can post and not post, which is not what the court is ordering. I believe that she should provide you, that you should be able to see what she posts and know that it has occurred. But the way you've presented it, it's essentially as if Ms. Richardson would be asking your permission to post it. And that's not what the court had anticipated or was expecting or intended to require.
Understood.
So rather it will be that if Ms. Richardson affirmatively undertakes to unblock Throttlebox and Mr. Wolf and whoever principals are, then when she posts, they will be able to bring that to your attention.
Thank you. And I wasn't attempting to be able to restrict it. I just want to know about it. I don't think she has to ask my permission based on your order. If though she is required to tag Throttlebox, if she makes a post, you know, and I'm not familiar with these social media things either, but I understand whether it's Instagram or Facebook, if she's doing what you've said, she should have no problem tagging Throttlebox so that Throttlebox then gets a flag that they can see that post and make sure that it's compliant. So if you would ask her to tag, I think that would cover my concern.
Ms. Richardson, is that doable?
Yes.
Okay.
Thank you, Your
Easy
Honor.
enough. Okay. Well, that is the order that I'm going to enter, just to be clear and to resolve this matter. So we all can be on your way. I am going to enter an order that looks very similar to the one that I already entered. It will be in effect through at least September the 5th. In looking at that date, I did reconsider, and I may push it to a little bit later in September, but it will be in September. And by that time, it will include a note that the parties have tentatively agreed to an August the 5th mediation date. Ms. Richardson, I think I've decided that what I'm going to do is I'm going to say that the parties, that absent a specific objection to Mr. Brogdon, that the parties have agreed to mediate the case with Mr. Brogdon on August the 5th. And if you have a specific objection or wish to recommend someone else, then y'all can try to work it out yourselves, or you can bring it to the court's attention. But I am going to make that be a specific objection by a certain date. So it will be, you know, next week or the week after, to try and give you some time, but make it reasonable so that if you do have an objection to Mr. Brogdon, the parties have time to try and find something else. Beyond that, I will include item 1 and item 4 as originally were in my order will remain. Items 2 and 3 will be massaged a little bit to discuss what we've talked about today, which is that the credit or the acknowledgement that will be listed is a Throttlebox Entertainment production, and that Ms. Richardson agrees to tag Throttlebox on social media posts, and that Ms. Richardson agrees to unblock Throttlebox Entertainment and its principals, who at a minimum include Mr. Wolf and Mr. Wolf, from social media so that they will be able to see the postings. However, as I've said, I will remind the parties that social media is not a platform for the parties to engage in communication and should not accept the lifting of the block as an opportunity or invitation to engage in communication, denigration, etc., on social media regarding this matter.
Understood.
That's going to be my ruling. Any last questions? Understand clarification, Ms. Richardson?
No, Your Honor.
Okay. Mr. Wolf, did you have your hand raised, sir?
Yes, just one thing. I know you're going to file your order the way you did the last time. When you file it this time, will you email it to Chris also so that that we
Yes.
have it?
Yeah, I don't understand what happened. Mr. Freehoff, I'm certain, is checking on it, but I suspect I will find that it was e-filed and not e-filed and served, which is a electronic function that's supposed to happen in e-file Georgia, but we will ensure that you receive it. And it will likely, because this is a holiday weekend, probably be beginning of next week, but it will get it on file for you as quickly as we can, and we will email a copy to everyone. Ms. Brown,
you.
any other questions?
will you not pro-tunc it to today, so it's in effect prior to the expiration of the 7th?
Yes, ma'am, I will. And if it needs to be said, for Ms. Richardson's benefit, the reason I go back over and verbally restate what my order is going to say is because my order is my order as of right now, because I have said it and directed the parties. Now, I am going to enter it in written form and it will be effective retroactively to today's date. Just want to let you know that, but just because I don't enter an order today doesn't mean that those requirements are not in effect already. Okay? Okay, thank you all very much. This
Thank you,
matter
Ron.
is adjourned. I'll get that order on file and I will see you or be in contact with you, hopefully to hear about a mediated resolution, but otherwise when it's time for us to enter a scheduling order and engage in discovery. Okay,
Thank you, Your Honor.
thank you all. Have a good day. Those of you who are here on the Jones versus Cummings matter, I apologize for the delay. If you could please give me just like another 5 minutes to get something to drink and clear my head, get my different set of notes in front of me for this matter, I would appreciate it. It's 3:15. I'll be back at 3:20. Thank you. Okay. Good afternoon, everyone. Mr. Roberts, I'm going to call this case and then have everybody make their announcements. This is going to be a hearing in the matter of Scott Jones versus Jennifer Cummings, case number 24 CV 004197. We are here on dueling motions for attorney's fees under OCGA 9-1514. Specifically, both parties filed their motions on April the 10th. Ms. Cummings' motion is docket number 66 in my record. Mr. Jones's motion is docket number 68 in my record. Who do I have here on behalf of Mr. Jones?
Ally Jett, Your Honor.
Okay, and who do I have here on behalf of Ms. Cummings?
Oh, Howard, Your Honor.
Okay, and I believe before we went on the record, I asked about the other party that had been in the case, Kellum Investments. They're not involved in these post-trial attorney's fees or post-judgment attorney's fees motions, correct, Ms. Jett, Mr. Howard?
Correct.
Yes, Judge.
Your Honor, I'm John Christie here for Mr. Robinson and his law firm.
Okay, thank you. Okay, so they were both filed on the same day. I guess one of them got into the docket faster, so we're going to go with that, which is to say that Ms. Cummings' motion for attorney's fees was filed first, and so just by that virtue, I'm going to call on Mr. Howard first to present the basis for his motion. I will note that previously there was some email traffic about whether the court expected this to be an evidentiary hearing. I do not. I believe that the parties have submitted a great deal of information to the court about the factual bases for why they think their requests, respective requests, are justified. And of course, the law is the law. And so I'm welcoming hearing from you in terms of what facts you think are important and to hear argument from you. And with that, Mr. Howard, I will hand it over to you, sir.
Thank you, Judge. Just a couple of minor procedural cleanups, I guess, before we go. One is my suggestion, given that it's 3:20 p.m., is that perhaps neither party present evidence on the amount of their attorney's fees or the response on the amount until we know whether the court intends to grant one of these motions or not. It might save some time. And it's possible that if we find ourselves at 5 p.m. and Your Honor is ready to go, that Mr. Christie and I could have a conference offline if we need to about the amounts and potentially work that out. He and I have a professional relationship, I think, outside of this case. I think could be fruitful. But if everyone was agreed to that procedure, I'd be happy to let's discuss whether any attorney's fees are going to be awarded and retire offline to discuss amongst ourselves, what amount would be appropriate. I offer that up for everyone's consideration, but Judge, if you're interested in that, we would be happy to proceed that way.
Ms. Jett, what are your thoughts?
I'm fine with that, Your Honor. I mean, I think if you determine that fees are awarded, we can talk about the amounts. And if you determine that nobody's entitled to any fees, then we don't need to spend our time talking about amounts.
Okay, Mr. Christie, what are your thoughts on behalf of Mr. Robinson?
Oh, you gotta give me a little grace here because I'm working these computers like this. It's not my forte, not my day job. I don't have any problem with it. I had a few remarks, very brief about the fees. I'd like to make those, but they're not going to go into any gruesome details. So I don't have an objection. And Mr. Howard and I do have a good working relationship. So perhaps,
Okay.
After this is over, we could have a discussion.
Okay, and if I'm not mistaken, I think that Ms. Cummings' ask is somewhere in the range of about 53, and Mr. Jones's ask is somewhere in the range of about 35. Am I
I think
generally
it's
around
74
that?
and 36.
Okay.
74 from Ms. Cummings, roughly, and 36.
Right. Okay.
So,
Forgive me for not having my numbers correct. Okay, and so, yeah, I think that's a reasonable request, Mr. Howard, and we'll deal with the amounts if we need to, understanding that all of you seem to be pretty reputable attorneys. I'm certain that your time is very valuable, and I would expect that if I reviewed in detail your billing records, that the only thing I might take issue with is perhaps work that was best suited to some other item or topic in the case rather than this one. But I'm certain that I would find they would all be justified in terms of the amount and the time. That's going to be my assumption in favor of all of you fine folks. Go ahead, Mr. Howard.
I think your assumption is accurate in terms of what arguments the parties are making as well. So that's can probably be cleaned up amongst us if necessary. Okay, Judge. Well, thank you very much for that. I appreciate it. My client, Jennifer Cummings, is here with me as she has been. I imagine this has been a frustrating case for her for a variety of reasons, but one reason in particular is that nothing ever happened on the merits. She was never called upon to give testimony. She never was asked to give her side of the story. Really, nothing happened really in this case, if you stop to think about it. The case started because my client, Ms. Cummings, was sued in a claim for ejectment by Mr. Jones. And that claim for ejectment is effectively a trespass claim. And Mr. Jones filed a verified petition in which he swore the truth of the allegations that he made to this court. And he claimed that my client's backyard fence and a piece of her shed was encroaching on his property. Now, his property, as he alleged it, is a piece of a roadway that we call, I guess, a paper street, but it's a piece of Schuyler Avenue, property that belonged to the city of Atlanta, that they began the process of abandoning in 1994, but did not complete. And Mr. Jones, his fundamental allegation is that he owned that property. He already owned it at the time that he filed the suit, and it would have been necessary for him to own it in order for him to have standing to sue to eject my client from it. We have discussed that a few times in this case, and I think that we're all on the same page that that's probably the law. He sued her not only for ejectment, but for attorney's fees under 13611, claiming that her pre-litigation conduct and forcing him to file the lawsuit would justify her having to pay his pre-litigation attorney's fees for this case. So he basically forced my client to hire a lawyer and defend herself from a claim that we know now to be false. We know that at the time that Mr. Jones filed this lawsuit, he didn't own Schuyler Avenue. In fact, what we know is that the city of Atlanta owned it, and we know that for a few reasons that I'll discuss here in a minute. A significant problem, of course, is that he didn't own the property that he was claiming to own, and that he swore under oath that he did own it. Despite this, he made repeated sworn allegations to the court that he owned the Schuyler Avenue right-of-way. He claimed in his pleadings, various pleadings, that he was not only the legal title holder, but the equitable title holder and the owner, in fact, of the property. At the same time that he was making those allegations to this court, what we have now learned is that he was negotiating vigorously with the city of Atlanta to try and buy the same property that he claimed to this court that he already owned. So at one side of his mouth, he's swearing to the court that he owns the property. Out of the other side of his mouth, he's trying to get the city of Atlanta to sell him the property. And he seemed, now that I can see his discovery, pretty desperate to get the property purchased. Why would he do this? Well, the city of Atlanta told Mr. Jones, and I'll show you this, that if he could just get my client, Ms. Cummings, to sign a document titled a certificate of intent, stating that she had no interest in purchasing the half of Schuyler Avenue that's adjacent to her property, that they would sell it to him. And why did he need to buy it so badly? Well, he needed to buy it so badly because he had already borrowed over $250,000 against his lot on the other side of Schuyler Avenue, 1097, based upon the premise that he would be acquiring Schuyler Avenue from the city of Atlanta. And then once he acquired Schuyler Avenue from the city of Atlanta, he and a gentleman named J.D. Kellum, whose company Kelco Real Estate, were going to essentially divide those two lots into 3 lots and build 3 houses on them. Mr. Jones's failure to purchase Schuyler Avenue from the city of Atlanta in a timely manner caused him to default on his loan obligations to Mr. Kellum. He was incurring default interest. Your Honor saw the counterclaim or cross-claim by Mr. Kellum against Mr. Jones. He was in debt to Mr. Kellum in an amount nearing $500,000, including interest. at the time of this litigation, and Mr. Jones had incurred additional debt to a hard money lender named Don Dollar, 6 figures, that he was trying to use to then acquire.
Great
Skylar.
name for a hard money lender, I have to say.
I also think it's fantastic. I say that meaning no disrespect to Mr. Dollar. I actually don't know who he is or what he does, other than the fact that his name is Don Dollar and he loaned up 6 figures to Mr. Jones in this case. Okay, so he had all this debt that he had to pay off, and his solution to the problem was to get Miss Cummings to sign a certificate of intent. If she would just sign it, the city of Atlanta told him that they would sell him the property. If they'd sell him the property, he could convey it to Kelco. If he could convey it to Kelco, he could go forward with his development deal and get himself out of trouble. So he undertook a pattern of, I guess, bullying my client. And he did that through this court. And he
Mr.
did
Howard,
it-
let me ask you a question, and I'm actually asking you to refresh my recollection. So
Certainly.
my recollection of the underlying facts about what ultimately happened is that there was some discussion of the fact that there was a process that Mr. Jones needed to go through for purposes for the city of Atlanta to acknowledge a claimed ownership interest in that abandoned property. And that ultimately he did go through that procedure. And I guess my question is, why did he require Ms. Cummings' permission to go through that procedure? Because I don't recall her giving it in the litigation, but that may just be my recollection.
She never gave it.
Okay.
There have been a number of different positions that Mr. Jones has taken, Judge. The city of Atlanta wanted to dispose of Schuyler Avenue. Their
I
position,
remember that part. They said we're abandoning it. Adjoining property owners have a right to claim it, but there was a process that had to be followed.
there's a process that had to be followed. And in fact, there's a city ordinance that explains the process in some detail, and it's Atlanta City Ordinance, maybe 138-9. And that is a general ordinance that governs abandonment in the city of Atlanta. And the 1994 abandonment action that the city council took was within the context of this general city abandonment ordinance. And I want to take you through later on in my argument how that process really is supposed to work, so that you can understand why the things that were claimed in this case were never true, or never going to be found to be true. But what the city of Atlanta's process requires, generally speaking, is that before property can be abandoned, meaning before the abandonment can be completed, all of the property owners who are going to take the abandoned property have to be specifically identified. And they have to be identified on a plat map that gets attached to the abandonment legislation. And when that happens, the property is appraised for fair market value. The Department of Transportation does this. And then the fair market values of the portions of the abandonment are relayed to the people who are going to obtain the property. And once they post the funds, once they post their money to the city of Atlanta into the coffers to acquire their property, then the city of Atlanta will turn around and issue a quitclaim deed. And the quitclaim deed completes the abandonment. And as I'll show you in the regulation in a little bit, until the money is posted and until those steps are followed, there is no abandonment. So a central portion of the arguments that were made early in this case by Mr. Jones and his counsel were that the property was abandoned in 1994 and therefore he owned it. But it's not that simple, because as I'm going to show you, the abandonment in 1994 didn't happen, at least not with respect to him. The process wasn't completed. He didn't own this property that he claimed to own. So what I would like to do is I'd like to walk Your Honor through the facts as they occurred, and show you what it is that we ultimately learned. Because during the course of this litigation, after 6 months of litigation in this case, Mr. Jones ultimately put the brakes on everything, because at that point, City of Atlanta changed city attorneys, and he ended up outside of the litigation buying the property from the City of Atlanta, which effectively mooted everything in the case. I mean, at that point, there was no more point to argue about law school questions about rules of perpetuities and things of that nature. which would have been
I
fun and
think I
interesting.
previously said not to say that phrase in my courtroom in this case because it gives me unpleasant flashbacks, but go ahead.
If you'd like, I'll send you $1 for contempt, but I agree. I agree. Nevertheless, there were a bunch of legal questions in this case that didn't have to get resolved because the city of Atlanta turned around and sold the property to Mr. Jones, and then he dismissed all of his claims. Okay. And he then filed an amendment to his declaratory judgment action where he makes a pretty specific admission. And the admission that he makes in his second amendment to declaratory judgment action is that at all times prior to when he received the quitclaim deed, the Schuyler Avenue property was in fact owned by the city of Atlanta. And he admits that for a reason. I think he had a reason to admit it. And the reason was if the city owned it, then Miss Cummings couldn't have taken the portion inside her fence by adverse possession. So strategically, he makes an admission that the initial allegation of his complaint that he owned the property was false. He made that allegation under oath twice, but he has admitted it now in judicio that what he started off with was a false allegation. That's also confirmed, by the way, by his 44 to whatever it is, 20 affidavit that he filed and we filed in the record of this court. It's confirmed by his agreement with the city of Atlanta to purchase the property, and we'll go through it in detail as we go through the facts. I just want to point out, Judge, that if the position that he's taking now were correct, which is that the property was really abandoned in 1994 and it was split down the center line and it attached to the adjacent lots, and that therefore when he owned Miss Cummings' lot back before she owned it, he also owned half of Schuyler Avenue. And then when he deeded the property down the line, he carved out with this less
Right, that except and unless or whatever language that was allegedly in there.
Yeah, he's made this argument a couple of times that what he was really doing is that he was selling 1085 Avondale, but he wasn't selling the Schuyler Avenue piece that he claimed that he already owned. That piece of his argument cannot succeed. And the reason why is because if in 1994 the property was actually split down the middle and attached to the prior owner's plots, they never sold it to him. You can actually go look at the deeds. He filed them, or he filed one of them. I filed the other one, attached to my motion for attorney's fees. But they spell out specifically what they're selling to him by meets and bounds. And if you follow the corners, the corner of Schuyler Avenue and Avondale, go around, what you see is that none of them sold him the property. And his own title attorney told him that this was going to be an issue, but he proceeded anyway. So I have now, after he told the court that he'd gotten a quitclaim deed and we had that hearing where your Honor said, I think Mr. Howard is going to have something to say about this. And we all found out that he had just bought this property that he'd been claiming that he was going to own. A few days after that, Mr. Hovorka, who's one of Mr. Jones's attorneys, finally gave me Mr. Jones's document production. And within it was pretty much all of the exhibits that I've attached to our motion for attorney's fees. Now, they're not bait stamped and they weren't bait stamped when I received them. But these all come from Mr. Jones's own email. And what you can see if you read them, and if you read them chronologically, is that starting in 2004, Mr. Jones was pretty clear in his intent that what he wanted from the city of Atlanta was he wanted to buy the Schuyler Avenue right away. And he made two big pushes to do this, Judge. And I'd like to take you through and show you the kinds of language that he and ultimately his attorneys were using in negotiating with the city of Atlanta, because it makes it very, very clear, if you read all of this, that he knew that he didn't own this property and that he was trying to acquire it. And that he knew these things at the same time that he was telling this court that he already owned the property. And so fundamentally, our position is under 915-14A, that he was taking a false position with the court, and one that he knew to be false, and one that he knew he was never going to be able to prove, because subjectively he knew he didn't own this property, and objectively it was impossible for him to own it as a matter of law. Go through that. But under 915-14B, we're also arguing that your Honor has discretion to award attorney's fees because this lawsuit lacked substantial justification, at least the piece of it where he's claiming that Miss Cummings was encroaching on his property, because while he was making those allegations, he knew that he did not own the property. He knew that he was trying to buy it, and yet he had no problem making allegations to this court under oath that he already owned it and that he was the legal and equitable title holder. If I may share my screen, Judge.
Mhm.
I'm not going to put anything on the screen that isn't already in the record. So I'm going to share my PDF of my volumes of our exhibits, if I can figure out
I have
how.
my folder right here ready to reference if you need me to, so.
I appreciate it. It may help me to look at them as I go through.
Sure.
Okay. I want to start with Exhibit 4. Can Your Honor see this?
Not yet. Right now, I'm still looking at a black screen, but now I see something that says Exhibit 4, and I think the next page is a June 23rd, 2004 letter with some handwriting on it.
Yes,
Yep.
Judge.
I'm looking at it.
All right. So this is the beginning of Mr. Jones's effort to acquire the Schuyler Avenue right-of-way from the city of Atlanta. So June 2004, he writes to Lowell Chambers, who's a city streets engineer. And he writes that the purpose of his letter is to request the city initiate the process for transfer of ownership of the abandoned property. So he's asking for transfer of ownership because he knows that the city owns this property and he would like to own it. He claims that the property was formerly a section of Schuyler Avenue and has been abandoned. And we'll go through later the ordinance that shows that the abandonment was in fact incomplete. But I don't fault Mr. Jones for that. I think what he's doing here is pretty straightforward, and I think you can't fault him personally for not having read, I don't think, the ordinance as closely as a lawyer would. But in 2004, he wants to buy the property from the city. If you go to Exhibit 5 in April of 2005, Judge, the city of Atlanta writes back, and this is somebody named Nursef Kadir, who's the manager of operations. And essentially what the manager of operations says is that it's the Department of Public Works position that since the abandoned right-of-way of Schuyler Avenue was never acquired, any acquisition must follow the current code. And then they go ahead and tell Mr. Jones that the code section is 138-9 and that it requires them to divide the abandoned right-of-way along its center line and transfer by quitclaim deed to the abutting property owners. And then you can read on if you care to read it, but that's the significant portion. Now, oddly enough, at this time, if Mr. Jones had proceeded down this path, I believe he actually was the abutting property owner on both sides of Schuyler Avenue. Timeline-wise, I think that either bears itself out or it doesn't, but I think that at this time, if he had followed up with the city of Atlanta, he potentially could have bought the whole thing, but he didn't. This is where the chain of correspondence falls off in terms of 2004 and 2005. He simply let it go. So the next thing that we have is Mr. Jones picks back up with the city of Atlanta in January of 2019, and he emails a person named Michael Jurgen. And Mr. Jurgen is going to work back and forth with Mr. Jones for a period of a couple, 2-3 years before he resigns from the city of Atlanta and moves on. But he tries to help facilitate this process. So in January of 2019, by this point, Mr. Jones has now sold 1085 Avondale, which is Miss Cummings, my client's property, but he still owns, or at that point, he owns 1097 Avondale, which is his property on the other side. And I'm assuming that Your Honor has a copy of my brief. I tried to include a map with some colors on there. I thought that might be helpful for the court, but I just remind you that that's there if you want to look at it. Now, here in 2019, what Mr. Jones says is that, again, his purpose is to, and he says it throughout, is to acquire the portion of Schuyler Avenue that fronts onto Avondale Avenue. And he goes on throughout this, and he talks about how back in 1994, the city had done the abandonment ordinance, and he attaches a copy of that to his letter. And he notes that a quarter of Schuyler Avenue back in 1994 got sold to a guy named Charles Lamar Samples. And he attaches a quitclaim deed that shows that the city actually sold a small piece of Schuyler Avenue off to Charles Samples, but it didn't sell the rest of it. Obviously, the city retained ownership of the rest of the party. And you can see down here, where at the bottom, actually, can you see the highlight when I do that? Okay, you can see down there at the bottom where he's talking about the quitclaim deed that he attaches, where the city of Atlanta conveyed a piece of the property to Charles Samples. And if you scroll down through the exhibit, what you can see is Mr. Jones has handwritten a plat. And this right here that I'm highlighting in blue, that's the Paper Street Schuyler Avenue. Now, all of this is just trees and weeds and stuff like that. The piece that I'm highlighting now, that's Ms. Cummings' property. That's 1085. And then this piece down here that I'm highlighting is Mr. Jones's property, 1097. Okay. And so this piece here that's got the slashes through it, this is Schuyler Avenue here. Now, Mr. Samples' property is behind Mr. Jones's, and it butts up to Edie Avenue, which you can see is handwritten on the street on the backside here. And so this little quarter right here of Schuyler Avenue was sold by quitclaim deed to Mr. Samples. The rest of it remains City of Atlanta property up until the quitclaim deed that was issued in this case. So I just want to point that out for the court, because the acknowledgement of Mr. Jones at this time is that that piece sold and the rest of this didn't sell. And that's going to factor back into when we look at the ordinance. All right. So moving forward, let me get through Exhibit 7 in February of 2019. So we've moved a little further into the future. Mr. Jones writes back to his contact at the city, Mr. Jurgen, hope all is well with you. He wants to follow up on the set of documents that he sent and ask for an application for the City of Atlanta for him to acquire the street. So he's again asking to acquire the property. He doesn't own it as of February 5, 2019. And Mr. Jurgen responds, as you can see up at the top, that he's going to meet with the law department later today to discuss several matters. And one of them is going to be Mr. Jones's request to acquire a portion of Schuyler Avenue from the city. So that's happening in February 2019. As we move forward, Mr. Jurgen writes back to Mr. Jones later in February. And this is potentially important. So what he says is that he is going to solicit bids for an appraisal of the property. They've been sent out, and he's looking at 7 different firms to appraise the property, because if the city is going to abandon the property and convey it to Mr. Jones, they're going to sell it to him for fair market value. That's going to assume that he has the right to acquire it. And then he says this down here in the 4th paragraph, Judge. The law department still wants us to submit new legislation once the appraised value is known and you agree to a purchase price. Although I have again appealed to not have to do that, we'll continue to ask for that reconsideration while the appraiser is valuing the portion, i.e. parcel, to be sold to you. So they're clearly discussing the sale of a portion of the property from the city to him. But what he's talking about here, where he's talking about new legislation, is he's talking about the city law department and its position that the 1994 abandonment was incomplete and was done improperly, and that it didn't transfer anything to anyone, and that they need a new piece of legislation. So you've seen that 1994 ordinance attached to a variety of pleadings in this case, Judge. The one that we at the very beginning of the case had a discussion of whether it meant that the property was abandoned or that it just expressed an intent to abandon the property in the future. I took that position, and Your Honor said you didn't buy the difference in shall be, and it was a verb tense argument. You didn't like it on a motion to dismiss, and I buy that. That's totally fine. But what we're going to show you later when we go through the ordinance is that the verb tense ended up being consistent with what we thought, that property was not abandoned. The city is going to repeatedly take the position that that is the case. So they're saying in February of 2019 that the appraisal firm is going to take 30 days to complete the report. And then they'll basically, if he wants to buy the property, he can let them know. So that's where they left it in February of 2019. The next exhibit is Exhibit 9, Judge, and this is an email chain between Mr. Jones and Mr. Jurgen. And moving from the bottom up, I apologize for scrolling back and forth if that makes anyone feel seasick, but on February 28th, Mr. Jones was writing back to Mr. Jurgen that he's written a couple of notes and hasn't seen a reply. He said he wants to move forward with buying the right-of-way. Do you have what you need to proceed? So again, Mr. Jones, in his own words, is saying he wants to buy the property from the city. And Mr. Jurgen comes back and gives him a lengthy response. And he's out of the office, and he must have missed the earlier emails. But there's two things that happen here. One is you can see Mr. Jurgen and Mr. Jones begin to talk about encroachments by the other property owner. Now, this is the third paragraph. I've highlighted it in blue. Those encroachments are the pieces of property that ultimately will become relevant to this case, right? That's the fence from Miss Cummings' backyard, and that's her
Sorry to
shed.
interrupt you, Mr. Howard, but I need to take just a brief moment. If I apologize for the abrupt interruption, but give me just 1 second.
Absolutely, Judge.
Sorry, Mr. Howard.
It's absolutely fine, Judge.
Thank you.
We're here for you. Actually, the fact that you took the break made me realize something that I had made a note to myself to tell you. The prior exhibit was in 2019. Mr. Jurgen and Mr. Jones were talking, and they've now jumped forward, you'll see, Judge, to February of 2022. So we've jumped forward about 3 years into the future. So the issue was let drop, but we're back. So that's why it kind of looked like it's the same day as the prior email, but it's 3 years later. So one of the issues that the parties are now discussing is Miss Cummings' backyard fence and her shed, which extend into the Schuyler Avenue right-of-way. And what Mr. Jurgen says is that there's some issue with the encroachments to the other property owner. And he says, we briefly discussed with the department that will have to handle those proceedings to get those encroachments removed. So the city is talking about perhaps taking care of the encroachments from Miss Cummings prior to conveying the property to Mr. Jones.
Mr.
He
Howard,
says, I think we have.
let me ask you a question.
Yes.
So my recollection from, although you have gone to great lengths, and I do appreciate it, to outline the full and complete history of this property, at least as it's relevant to this case. And I think it's helpful, but I understand that Ms. Cummings takes issue with the fact that Mr. Jones, to their way of thinking, did not actually own the property at the time that he attempted to eject her from it or caused her to incur attorney's fees to defend herself from an ejectment action. But as it developed, it sort of seemed as if Mr. Jones' sort of backup position was that he essentially was the equitable owner, even if not the actual owner. And what I suspect is that what all of these documents demonstrate is that he was not the actual owner at any time he claimed to be. But
Yes.
what of a claim of equitable ownership? Does that not imbue him with the rights, with at least some standing to attempt to vindicate his rights relative to this property and as it abuts Miss Cummings' property?
Well, it's a good question, and I'll answer it. I'll answer it two ways. He had a contract to purchase the property. Eventually, you will see that what he had was a contract to purchase the property from the city of Atlanta, and the city told him that if they could get through the process, he would have the right to purchase the property. And his contractual agreement stated that he would not own the property until he had paid the money and received the quitclaim deed. So perhaps that's legal ownership, but he did not have I don't believe he had equitable ownership either until he actually paid the money and got the quitclaim deed, at which point he had both legal and equitable title. But the law is pretty straightforward. It says that in order to have standing to eject somebody from property, you have to be the current title holder. He has to hold title, and he didn't. And what I'm ultimately trying to show you here is that he knew it. Now, the other thing is that the city of Atlanta did the purchase and sale agreement with him. And we can jump forward to it if you would like, but they did the purchase and sale agreement with him after discussing with him the fact that the city was not going to clear the encroachments, and he was going to need to wait until after he closed the deal and acquired the property, and then he could deal with the encroachments at that time as he saw fit. But until then, the city intended not to do anything about it, and it was the city's property. And so that was one of the conditions of the negotiations between the city and Mr. Jones, and he went forward with the deal on that basis. So he doesn't really have an equitable claim that he should be entitled to clean this up prior to owning the property either.
Is there anyone else who had, other than the city of Atlanta, I guess by default, owning that property because they didn't properly abandon it? Was there anyone else who could have claimed ownership to it besides Mr. Jones?
If I understand your question, for a long time, the city of Atlanta was saying under its ordinances, Ms. Cummings had the right to also petition to acquire the half that was adjacent to her property. Now, and we can discuss the less and accept provision and whether that would impact that. But essentially what they were saying, and that they were telling her, and I will show you that they were telling her, is that if you sign this piece of paper that says you intend to acquire it and you're willing to pay fair market value, we're willing to let you initiate abandonment proceedings as well. I mean, the central falsity, or one of them, of the plaintiff's case was that the property had been abandoned in 1994. It didn't happen that way. He was petitioning for abandonment in 1999 and in 2022, and what the city was saying was, in our contract, you can buy this property as long as you meet the terms of the ordinance. And one of those terms is you have to have the right to buy both sides of it. And he said, well, I do have the right. And he gave him a copy of the deed, which I'm going to show you, that has the less and accept provision. And an attorney named Ashley Vanderland at the city law department came back to him and said, we've reviewed the deed, but it doesn't give you the right to buy the property. You need to get some sort of agreement from Ms. Cummings that you can buy the piece that's on her side. So that was the city's position up until the city got sued. Then they changed attorneys and they hired Ms. Perkins Hooker, and then something happened behind the scenes, and we'll have a discussion about what that thing was. And then out of the blue, the city sold them the property. Mr. Jones takes the position that they changed their policy. Maybe they did, but there was an email from Mr. Kellum that he was good buddies with the city attorney's husband, and they were going to have dinner together, and he was going to take the opportunity to persuade them to sell the property anyway. So that's what I think happened, because that's what they said was going to happen. So anyway, I don't believe he had any equitable or legal right to do anything with this property prior to owning it. And he got his quitclaim deed during this case, and so he dragged us through 6 months of litigation on pain of attorney's fees, claiming to own property that he knew he didn't own. Does that answer your Honor's question?
It does.
Okay. So the city also says, and the other thing that the city says is that they're going to have a meeting with the law department to discuss new legislation. Meaning is they're going to have to be a new ordinance, kind of like the 1994 one, but are we going to have to do it right this time? So that's where Mr. Jurgen left it on February 28th of 2022. And what you'll see is that Mr. Jurgen next sets up a meeting with somebody else in the city of Atlanta named German Negesi, where they want to talk about what the city of Atlanta could do potentially to move the encroachments. So that's the next exhibit. And then exhibit 11, Mr. Jurgen comes back and basically says two things. One, he says in March of 22, law so far has said verbally that the old legislation is too weak to make it through this time around, meaning they're going to have to redo the legislation to abandon the property. And he also says that they have told him, let's see if I can find this. They've told him that, the transportation department does not plan to do anything about the encroachment issue. And he wants to know from Mr. Jones if it's okay that the encroachments remain until he owns the property. Let them know, and then they'll move forward with abandoning and working with them. So that's March of 2022, Judge. Then in April of 2022, the city of Atlanta basically sends a copy of the purchase agreement for the portion of Schuyler Avenue to Mr. Jones by email. So they're saying, here's, as promised, here's the election agreement. You need to sign and have it notarized. Then they tell him that he'll get the property by quitclaim deed after he wires the funds, which is all consistent with what this agreement ultimately says. And that was April of 2022. I'm going to try and move quickly here. This is a copy of the agreement. I don't know why it's here. It's a signed copy that came back in May. So we'll get back to that. But Mr. Jones in late April writes back to Mr. Jurgen and says that he spoke with an attorney and they advised one change to the contract, and he put in bold words. And then he said, let's see here if I can find what it is that he said. Mr. Jurgen says, that's fine. Feel free to confirm and do any due diligence. And he wants to, you can send him back the copy of the contract that's, that's redlined. That's April of 22. And then this is where May of 22, where we get down to the day when the agreement was actually signed. But leading up to it, Mr. Jones writes to Mr. Jurgen and says he's ready to move forward with purchasing the abandoned Schuyler Avenue. Please keep me posted in the process of various COA updates. So he's talking about purchasing it. And then he writes the next day, Mr. Jurgen asks for a marked up version of the contract. If you can see this, I don't know if it's clear enough to read on your end, Judge.
Well, it's in blue, so it actually was easier to read before you highlighted it.
My apologies. So please send over a marked up version of the contract. And this is kind of funny, that you and your attorney are asking to be changed, and we will loll at it, and then we'll go from there. So the city is saying they're going to laugh at his provisions. And Mr. Jones says, that's pretty funny, Mike. I'm not the best at that kind of thing, modifying docs. I will try. It's really almost a correct language change than a legal one, though I realize every contract is in a sense legal. The way it reads on the contract you sent makes it appear that I own the right of way already. So he's now acknowledging in really clear terms in May of 2022 that the contract needs to be revised because it might accidentally misrepresent his ownership. And so they work this out, and then ultimately the contract was signed and sent later on the 25th. Here's a copy of the contract. We've looked at this before, but just to remind Your Honor, the contract sets a purchase price of $110,000 for the entirety of the abandoned Schuyler Avenue. In it, Mr. Jones agrees in Section B that he's currently the legal owner of record of the abutting right-of-way or has a recorded legal right to acquire the abandoned portions as identified in the exhibits. So a provision of this agreement is that he either actually owns the abutting property or has a right to acquire. And that's going to become an issue later on down the road. He acknowledges that title in Section C is going to be transferred by quitclaim deed. And so that he's not going to have title until he gets the quitclaim deed. That's part of his acknowledgement. He acknowledges that the quitclaim deed is going to reserve any and all existing public utilities or easements. He says that full payment is going to be by wired funds only here in paragraph E, and that no funds will be required until wiring instructions are issued. And then basically it says that that they'll let him know when it's time to wire the money. And then if you go on to the next page, Section H, he acknowledges that the identified portion of the right-of-way transferred will become part of his property and will be his responsibility to maintain. So it's going to become part of his property. And he acknowledges, let's see here, in paragraph K, that ownership transfers to him upon the issuance of the quitclaim deed. And then he signs this agreement and he sends it back to the city of Atlanta. So by his own contract, he's acknowledging that until he gets a quitclaim deed from the city, after he pays the funds, he will not own this property. So he acknowledges the city owns it. Judge, I feel like at this point I'm going to start belaboring the point of some of these exhibits, and I know Your Honor is a very careful judge and probably has read everything that we filed. If I am trying the court's patience, please let me know, and I can move this forward. But if this is helpful to the court, I'll continue through, because I think this stuff is telling.
You're not trying my patience. You're just being thorough. And that's what I would expect from you. But I feel like your instinct to move forward is probably a good one, simply because I have not in anywhere near, I will never understand all of these matters in anywhere near the detail that all of you have become familiar. I feel like, having reviewed them and having dealt with the initial motions practice in the original underlying case, that the status of Mr. Jones' claimed interest in the property was one that I thought I understood pretty well, in the sense that he didn't actually own the property. There was an open question, at least my recollection was an equitable claim or claim of right, but that Ms. Cummings' position has always been that even if it was an equitable claim of right, he didn't own the property. And he wasn't taking the position that equitably he ought to own the property. He was taking the position that he owned it.
That's correct. I mean, our position has been that if he had showed up in front of the court with a declaratory judgment action saying, I'm not sure whether I own this or not, can you let me know what my rights are, that the defense would have been materially different. It would have been, well, we signed this thing, we'd like to purchase part of it, but he wouldn't have been threatening her with attorney's fees and trying to force her to sign.
But then, as I typically rely on people like Ms. Bryant to tell me in quiet title actions, then you run the risk of a court saying, no, Mr. Jones, you don't own this, or you only own half of it because you're only adjoining. If the original abandonment rules are to apply, right, then he would only own the half that adjoins the property he still owned at the time, not Ms. Cummings' half.
That's right. And that's a risk that he would run by filing litigation. But as it stood, he didn't have a quitclaim deed. He didn't own any portion of the property. And I mean, his remedy is, if he wants to ask the court for some guidance about what the law says, but his remedy should not be, under any version of the facts, to make a misrepresentation that he's not only the equitable but legal title holder of the property. I mean, you will recall, Judge, that his initial petition and his amended petition, where he added his quiet title claim, he affirmatively alleges and he verifies the allegation that he's the legal title holder of this property at the time that he makes the allegation, which is just false. I mean, it is a false claim. And he makes that allegation so that he can sue her for ejectment from property that he claims to own, which he doesn't own at the time. So that's the point there. I will endeavor to move forward down the line here. Mr. Juergen leaves the city of Atlanta. And then what we have is the next thing that happens after Mr. Jones signs the purchase and sale agreement with the city of Atlanta is he does this promissory note with Kelco Real Estate Investments for $230,000. And you'll see that it's 10% interest, and it's a maturity of 12 months, Judge. And
let me ask you a question, Mr. Howard, because you spent a good deal of time in your briefing talking about what you believe was the motivating factor for the ejectment, and specifically your, I guess, better developed after the litigation, the underlying litigation about the property, your better developed understanding of what might have been motivating Mr. Jones. Why why do you think that is important if for the court to consider in considering a 9-15-14 action against Mr. Jones?
Well, I think under 9-15-14B, if he has an action that lacks substantial justification and he's pursuing it to harass my client, which is what the statute literally says, the fact that he has a significant financial motive to harass my client is a relevant factor.
Okay.
And if he's about to lose all of his property and interest on a $500,000 debt, and the only thing he needs to do is he needs to convince Jennifer Cummings by hook or by crook to sign a certificate of intent stating that she doesn't want to buy half of Schuyler Avenue, then a really reasonable way to do that would be to sue her for, an ejectment claim and attorney's fees and threaten her with attorney's fees and all of this. And one would wonder why a person would do that. Well, I wouldn't personally stake my reputation on it. I think it's a kind of an awful thing to do to a person. But if you had a $500,000 problem, maybe you could understand why somebody in that kind of desperate circumstance would take that action.
And what about Mr. Jones's pointing to the efforts to pay Ms. Cummings, right? I think there was some recitation of maybe an original $5,000 offer and then an original $35,000 offer. And how does that play here in terms of their good faith efforts to resolve the issue?
Well, so what he's really getting into is he's getting into settlement discussions.
Setting aside the whole setting that part aside, where we are now, what about that?
Well, what she wanted was to buy her half of the property. And so when he comes to her and says, I'm offering you $30,000, which I guess he's put it in the record so we can talk about it, but I'm offering you $30,000 for you to disclaim your right to buy that half of the property so that I can buy it. It just lets you know how serious it was that he wanted it. I mean, he has a really serious need to buy this piece of property, but what he doesn't have is a right to force her to sign this piece of paper. I mean, there's nothing, even if the world went the way that Mr. Jones wanted and his less and accept provision gave him the right to buy the whole piece of property, which we disagree with. But even if that were the case, it doesn't give him some sort of legal or contractual right to tell her that she has to make a false representation about her desire to buy the part next to her property. And if the city of Atlanta is saying, yeah, we'll sell it to you if you want it, then she has no obligation to just give that away. So, the question in my mind is not whether she could have avoided all this if she had just accepted his $30,000. The question is, did she have to? And she didn't. She didn't have a legal right to take his $30,000 and give away a piece of property that would have been valuable to her. I mean, the property.
I didn't mean to imply that it did, Mr. Howard, as much as at the moment I asked that question, you were talking about Jones. You were characterizing Jones's efforts as harassment.
Right.
And so I was asking, how does what appear to be, offers to Ms. Cummings to disclaim her interest play into your characterization of his actions during that time as harassment? So that's
oh,
why
I'm
was
sorry.
asking.
I understand your question. Offering her $30,000 is not harassment, I don't think. But telling her that if she doesn't sign this piece of paper, you're going to sue her and recover your attorney's fees and drag her through court, that starts to become harassment. And then filing a lawsuit based upon a false allegation of ownership so that you can make that attorney's fees claim, I think, is harassment. So, pre-litigation offer to settle for $5,000 or $30,000 is fine. I think parties do that all the time. But it's once he gets into the range of once he and his lawyer start telling her that the guy already owns the property when it's not true and that they're going to eject her from it, that becomes legally harassing because it's just a false claim. They're just making false allegations. I'll try and skirt through. I think we understand my position on the Kelco and piece of all of this just fine. So what I'm going to do is I'm going to try and pop down to let's see here. Exhibit 18, Judge,
Okay.
is an email conveying the city of Atlanta's appraisal document. And if you read through it, what I'll represent is that what they're doing here is the city of Atlanta, through all of its internal processes, is affirming they own this property. They're setting a price at which they're going to sell it to Mr. Jones if they can get through the process. So that's the appraisal, and I'm going to try and move past that document and see if I can make my way down to something that'll bring us closer to time. It was interesting. I happen to know the appraiser because I've worked with him a few times, and so I called him, and he said that they had done a couple of 2-3 appraisals regarding this property, because when the city of Atlanta ultimately told Mr. Jones that he wasn't going to be able to buy the entirety of the property, Mr. Jones and his lawyers at that point took a fallback position with the city, which was they would like to just buy half of it, please. And so the city reappraised his half of the property.
It was the half that adjoined the property he still owned, right?
That's right. And so
Okay.
they went through that whole process, and presumably they couldn't get to the end of it. And so that's going to bring us pretty much forward to where he sues my client. I just want to point out one piece of correspondence before we get there. And I think this is the end of that volume of this. If you'll excuse me just 1 second, Judge.
Sure.
You sent me this to make a red weld.
Hang on, you're not muted, Miss Bryant.
Sorry about that.
That's okay.
Reshare my PDF, and then we can get on. My expectation is that everybody was hoping I'd be briefer than this, since this is the day before July 4th, and I apologize.
It's okay.
Okay. This is Exhibit 20, Judge, and it's a copy of a plat map. This is essentially what I showed you earlier in Mr. Jones's handwriting. The city of Atlanta, this is a map prepared by the city of Atlanta. And you see these 2 yellow parcels. The one on the right side is 1085, that's Ms. Cummings' property. And the one on the left side is 1097, that's Mr. Jones's property. And then this green piece back here is the piece that got sold to Charles Samples back in 1994. It's interesting that the city of Atlanta's plat map thought that that this property over here that's actually owned by Ms. Cummings was owned by Mr. Jones at the time. That's what they seemed to be under the impression of while they were negotiating with him. And if you pop down, to subsequent pages of this exhibit, what you'll see is that the person who's preparing all of the annotations on this document is Miss Glenn Snooks from the city of Atlanta. And so you can set at the time that she made these annotations is November of 2022. So in November of 2022, the people at the city of Atlanta who were responsible for this transaction seemed to be under the impression that Mr. Jones owned the property on both sides, claiming that they're both owned by the petitioner. So that is a fact that may come back to bite Mr. Jones down the road as he continues to negotiate with the city of Atlanta. Now, apologies, this computer runs kind of slow. I think it's probably because I'm on Zoom here. when you jump forward to Exhibit 21, what we have is Mr. Jones and Mr. Kellum discussing a letter that they want to write to Councilman Jason Winston about their efforts to buy this property from the city of Atlanta. And they have in this letter, he's talking about how he is still trying to acquire the property, and that he believes that he's only a few steps away from completing a purchase, and he's looking for help from the councilman to get it done. Now, this is a draft that Mr. Jones and Mr. Kellum are exchanging back and forth between themselves before he sends it on to Councilman Winston. But you can tell that behind the scenes, Mr. Jones and his lender understood that even at this time in January of 2023, they had not yet completed a purchase from the city of Atlanta. Moving forward, we have Exhibit 22 is when the city of Atlanta starts to figure out that they need some authority or approval from Ms. Cummings to do this transaction. And so what you'll see is that Bashan Mann, who becomes the point of contact for the city, is emailing German DeGessie asking for a blank copy of the certificate of intent. Now, that certificate of intent he's asking for is the document that it's attached to the city's right-of-way handbook, and it's referenced in its abandonment ordinance. And basically what he's saying is that the petitioner still has to produce acknowledgement from the adjacent owner that they do not want to purchase. And I was told that the certificate of intent will be able to serve as that acknowledgement. The petitioner will have the adjacent owner sign that form, I'm guessing. So this is May of 2023. Internally at the city of Atlanta, they're talking about how if Mr. Jones can convince Ms. Cummings to sign the certificate of intent, they can move forward with this process. And then that gets emailed from Mr. Mann to Mr. Jones on May 25th of 2023. Now, from there forward, what we see in the exhibits is a series of increasingly aggressive communications between Mr. Jones and Ms. Cummings about her need to sign the certificate of intent. Well, this is what the blank certificate of intent looks like, Judge. They ask the property owners adjacent to the right-of-way to sign this thing and to have it notarized. And what they do is they give the property owner a choice. So they give the property owner the choice to either support or not support the abandonment. But then if abandoned, it gives them the opportunity to say, I will or will not acquire at fair market value that portion of the right-of-way abutting my property. So this is the document that they gave to Mr. Jones and asked him to present to Ms. Cummings to sign. And she ultimately signed one of these. I think there's a copy in the record before the court. She said that she would acquire the property at fair market value in the event that they abandon the property. So that was what she ultimately indicated. And she sent that to Bashan Mann. So the city of Atlanta ultimately got her response to this. Now, on May 30th, Mr. Jones wrote to Bashan Mann and said he was hand delivering a letter to Ms. Cummings and advised her that he had a contract with the city to purchase the Schuyler right-of-way and attached to it, let's see, he said, once title transfer of the right-of-way is complete, I will offer to move both shed and fence at my expense. And that's Exhibit 23. So he's telling Ms. Cummings at this time on May 30th, he's telling her that he's a copy of a letter or telling Bashan Mann that here's a copy of a letter. And then he has a handwritten letter that he's taken a photo of, Judge, and attached it to his email. And you can see that it's a little difficult to read. But what he tells her is that the purpose of his letter is that he has a contract with the city of Atlanta to purchase the abandoned Schuyler Avenue right-of-way. And he says he used to own 1085, and he tells her about that. He says, if you have any questions or concerns, please contact me. And then on the next page of his letter, he gives her Bashan Mann's contact information. And he says, your backyard shed and fence will need to be moved off the right-of-way. He says, I realize this is an inconvenience and expense unexpected by you. So Once the title transfer of the right-of-way is complete, I will offer to move both shed and fence at my expense. So he tells her then, after he acquires the property, he will then offer to move the shed and fence at his expense, but that's not what happens. What happens is he starts sending her increasingly aggressive letters. And so Exhibit 24, he follows up with her and he says that the city of Atlanta requires any landowners adjacent to potential right-of-way sales to expressly disclaim any interest in purchasing the property. And he said, it's my interest that you do not wish to purchase the right-of-way. So he was mistaken about that. She did wish to purchase it. And then on June 5th, Mr. Mann emails, Mr. Jones emails Mr. Mann, attaches his certificate of intent, and Mr. Mann confirms back to Mr. Jones that he hasn't heard anything from Ms. Cummings, but all she needs to do is sign and we should be good, meaning that the city of Atlanta still requires her to sign her certificate of intent before they will move forward with the sale. Exhibit 26 is when Mr. Robinson gets involved, and Mr. Robinson, and you can see who he's conferring with here. He's conferring with Mr. Kellum and Mr. Havorka and with Mr. Jones. Excuse me. And what he has prepared is a version of Mr. Jones's 44-220 affidavit that he filed in the real property records of Fulton County. And in that affidavit, excuse me, let me scroll back up. In that affidavit, I tell you what, we'll just look at the affidavit later and I won't tell you what it says now, but you can just see that Mr. Jones on July 5th is starting to prepare that. On July 17th, 2023, which is my birthday, what you will find in Exhibit 27 is that Mr. Jones, Mr. Kellum, and Mr. Robinson are discussing. And what Mr. Jones says is that the sticking point for the city completing the sale, according to statements from Bashan Mann and the city and staff attorney Ashley Vanderland, are concerned with two matters related to public notice. One issue was that the city could not find proof that the proper abandonment procedures were followed in 1994, respecting notice. A second issue related to Ms. Cummings, Mr. Jones wrote, the city preference was for Ms. Cummings to sign an affidavit saying she approved of my purchase, or at least that she didn't want to purchase part of the right-of-way. I believe that the city didn't want legal trouble from Ms. Cummings based on her potential claim that the city did not follow its own protocol procedures in selling the right-of-way. So Mr. Jones is telling his attorneys as of July of 2023 that the city doesn't think that the abandonment was proper, and it didn't want to get sued by Ms. Cummings. So the following day, we have the filing of Mr. Jones's 44-220 affidavit, where he indicates that not that he owns the property, but that he has a right to acquire a portion of Schuyler Avenue. And what he says, specifically, Judge, is that in paragraph 3, he signed a purchase and, he signed an election to purchase agreement, and that the election to purchase agreement is what gives him the right to the property. And so if you scroll down to Exhibit C to this affidavit, you'll see that the election to purchase is this same document that we looked at previously that says that he won't own the property until he gets a quitclaim deed after he pays. So his affidavit publicly states that he doesn't own the property yet, but that he has a right to acquire it pursuant to this contract. Following this, we move toward litigation pretty quickly. And what we have is Mr. Robinson starts writing letters to the city attorney, and he starts writing letters to Ms. Cummings. And so what he's telling the city attorney is that Mr. Jones is trying to tender the money for the purchase of the property, and that they won't sell it to him, and that the city is essentially subjecting itself to a claim. And what he's telling Ms. Cummings at the same time, as you will see, well, ultimately, he tells Ms. Cummings that Mr. Jones actually already owns the property. So,
Mr. Howard, let me interrupt you for a second. And mainly, I'm only interrupting you because you've been going for about an hour now.
sure.
And I want for a moment to assume that it was clear to me in the litigation, right? Even though ultimately the court wasn't called upon to decide it, that Mr. Jones didn't own the property when he initiated the lawsuit.
Okay.
And I'm assuming that your, very thorough recitation of all the different representations that he's made are evidence of sort of the not only untrue nature of the assertion that he owned the property, but demonstration that Mr. Jones and Mr. Robinson understood that he didn't
Correct.
own the property, but we're still making those representations. And then I note that when you get into your later your later exhibits, right, in support of your motion, it really is more focused on some of the disagreements that are going on in the litigation in terms of, Kellum's involvement and that sort of stuff. And am I correct that at its simplest, Kellum's involvement to you, as it's most important here for purposes of your motion, is that it underscores what the pressure that Mr. Jones, the motivation for Mr. Jones to make these allegedly untrue statements about his property ownership interests, equitable or actual?
Yes, Judge, I think you understand that.
Okay.
That's exactly. I don't intend to dig back into the litigation or to Mr. Kellum and that issue. The one thing that I did want to highlight is that on the day that the lawsuit was filed, and I'm going to try and jump forward so that I can avoid, burdening the record further. But on the day that the lawsuit was filed, Mr. Jones also sent an anti-litem letter to the city of Atlanta, basically telling the city that it was going to sue the city if it didn't sell them the property. So really what you have is the very same day he's threatening to sue the city of Atlanta. He does sue Ms. Cummings. And claims that he owns the property. So he's making really these two different representations to these two different parties at the same time. Just the one that he makes to the court is under oath and is false. And then of course he says that he owns the property over and over in a variety of ways. And the reason he says that he owns the property is because he claims it was abandoned in 1994. And he claims that it was, it became his, which we know isn't true because of all of this. So let me see if I can sum up
One
or
quick question before you do that. I would like you to clarify. You said he anti-litems the city, that he's going to sue them.
Correct.
For what, refusing to complete the sale of the abandoned property?
That's correct, Judge.
Okay, thank you. Go ahead.
And the anti-litem notice or letter is in the record. If Your Honor ever wants to read it, it's attached to volume 2 of our exhibits.
Okay, I have that in front of me. Do you know which exhibit number it is, just so I have easy reference in my notes?
I was just looking for it, and I think it'll be easier if I look over at my iPad for just a moment. I apologize,
No
but
problem.
it's exhibit 45.
Thank you. And I'm sorry, Mr. Howard, you were starting to speak and then I interrupted you with that question. Please go ahead.
Oh, it's okay. I wanted to show the court exhibit 52, which is the actual abandonment ordinance. And I wanted to talk about it just a little bit because I think it's important that we note when Mr. Jones and when his counsel have responded to our motion for attorney's fees, they have agreed with me that Atlanta City Ordinance 138-9 is governing here. In fact, they've said in 11 different places in both of their briefs that 138-9 was complied with. They've said that 138-9 was directed to be complied with by the 1994 legislation. I mean, I can be happy to cite pages, but I think if Your Honor looks, you will see that that ordinance is referenced throughout their briefing. And the actual ordinance is attached as Exhibit 52 to our motion. And I'm just going to scroll forward there so I can show Your Honor a couple of things in it. Sorry, it scrolls slowly. I tell you what, if Your Honor wants to just look at the hard copy of
I'm
Exhibit
looking at
52,
it
I
now.
can just point you. Okay, it's a little bit dense, but in section I,
I've never met a
48.9,
city
section I,
ordinance that was plainly written ever, so.
fair enough. It says streets or right-of-way having been abandoned shall be divided along the center line and transferred by quitclaim deeds, or shall be transferred by quitclaim deed to the abutting property owners along each side of the abandoned right-of-way in sections defined by extension of existing property lines. Said transfer shall be conditioned upon the abutting property owner having posted funds as outlined in paragraph E above. So it's city ordinance that you don't get the transfer, you don't get the quitclaim deed until you have posted the funds. So that's point one. And then if you go on down to section J1 of the ordinance, Judge, it's kind of in the middle of that section, but it says further, no abandonment shall occur until all portions of the right-of-way are identified and accounted for as to whom shall be the receiving owner and appropriate funds have been posted. So Your Honor will probably recall there's been a lot of talk about, the property was abandoned in 1994, but the ordinance that governs all of this states that the completion of the abandonment doesn't actually happen until the funds are posted and the quitclaim deed transfers the property. And there's a couple of legal reasons for this, and I think we can understand them. It is if there's some cases that Mr. Jones and his attorneys have cited in his response to our motion. One of them is a Georgia Supreme Court case from 2006, and the other one's a Court of Appeals case from sometime later. I can't remember if it's 2014, but what they say is essentially the same thing, that when property is abandoned, it gets divided down its center line and it attaches to the adjacent property. And Mr. Robinson has argued to the court on numerous occasions in briefs that that's what happened in this case, that the property was actually divided in 1994, the Schuyler Avenue property, and attached to the adjacent lots, which is the basis of his claim that Mr. Jones actually owns Schuyler Avenue. And it's the basis of his claim that when Mr. Jones conveyed Schuyler Avenue, conveyed 1085, less and accept any right to own Schuyler Avenue, he's actually just retaining ownership of some property that he already owned. But what
do we know? So my review of this ordinance, if hopefully it is properly following legislative history rules, is that this was enacted in 1977 and that it wasn't amended until after this property was allegedly abandoned in 1994. Do we know what the provision you're pointing the court to was in effect in 1977, or do we have any way of knowing that?
Actually, I found the old code online. It was on, I think it's either the University of Georgia or it was on either the University of Georgia or it was on archive.org, one or the other. But the old code was there. And so this is, I believe, the ordinance, because this is what is described by the city attorneys in all their correspondence with Mr. Jones. Mm-hmm. So that's the process that this is describing is what they're talking about. And it's what's described in his purchase and sale agreement with the city of Atlanta as well. But the ordinance is fairly clear. And unless council has a different version of the ordinance, which I don't believe they do, they have agreed that this is what the rules are. And the rules say that there isn't an abandonment until the funds have been posted and the quitclaim deed has been issued. Mm-hmm. And so that's understandable, because the city's process is we have to have a piece of legislation that says we're going to abandon the property, and then everybody has got to agree that they want to buy it after they find out what it's going to cost.
Because
And
otherwise,
if-
it's a practical matter, there's not a clear record of the property having actually changed hands. Someone has to own the property. If the city owns it,
Right.
then they own it until someone else owns it.
And if the abandonment happens the moment they pass that piece of legislation that says, well, it's no more use to us, so we're going to abandon it, then nobody would ever pay for it, right? Because people like Mr. Jones could come forward and quiet title without ever having paid the money, because they would say, oh no, it's already been abandoned. And because it was abandoned, it became mine as a matter of law. So to avoid that, the ordinance says that the abandonment process isn't complete until a couple of things. And one of those things is you have to attach a plat map to the back of the legislation that shows who's going to get every piece and what they're going to pay. And there's nothing like that in this case. That doesn't exist. And then the other thing that didn't happen is obviously nobody bought these pieces back in 1994. And so the abandonment was incomplete. And there was no abandonment. Mr. Jones was petitioning for abandonment in this case. And so again, this just goes back to our position that he sued our client to eject her from property that he did not yet own, and had agreed with the city of Atlanta that he agreed that he was going to buy it, but they needed him to demonstrate that he had the right to buy it. He never actually got through that process in this litigation. The only thing that we know for sure happened is at some point the city of Atlanta decided it didn't want to fight about this, and so it sold him the property behind the scenes. They've been pretty cagey about what their position was and why they decided to do that, but there is no ruling on the merits in favor of Mr. Jones on any issue in this case.
Okay, Mr. Howard, sorry to interrupt. I have one more question for you. And then given the cross motion nature of all of this, I feel like you will have a substantial opportunity to respond, both to arguments that the other side will make as to why I should not award fees in your favor, and also why I should not award fees in favor of Mr. Jones. And so I'm going to cut you off a little bit, but give you a brief moment to have a last word for the moment with this question. So I think I understand your basic theory in terms of, both 915.14a and 915.14b. I do want to ask you, I have heard a lot about Mr. Jones, and it seems as if Mr. Jones is a somewhat sophisticated property owner. Other than seeing Mr. Robinson's name on various letters and of course his signature on the pleadings that were initially filed, I've not heard a lot about Mr. Robinson, but you very pointedly have requested recovery because obviously 915.14 allows either or both. And you very pointedly requested recovery as well from Mr. Robinson. Is that because legally you're entitled to ask, or is it, help me understand the specific theory about why you think Mr. Robinson should be on the hook for this as well?
Sure, Judge. Mr. Robinson is the one who, if you read through the correspondence, and I glossed over some of the later letters because I got the sense that I was trying everyone's patience. But if you read the correspondence, it's Mr. Robinson who comes up with the theory that the property already belonged to Mr. Jones. I mean, at all points, really, Mr. Jones was taking the position that I don't own this property yet. I need to own this property. I'm trying to buy this property. Mr. Robinson comes along, and it is his theory based upon these two cases, one from the Georgia Court of Appeals and one from the Georgia Supreme Court, that perhaps he already owned it because the property was already split down the middle, and as a matter of law, it already became. And so he started taking that position. In fact, he sent one letter to my client, Ms. Cummings, on his letterhead stating that his client had the right to buy the property. And then 8 days later, he sent a second letter to my client, Ms. Cummings, and told her that his client already owned the property. Did not explain what had changed, but we can see that Mr. Robinson is the one behind the scenes who has come up with this theory that maybe he already owns it. Mr. Robinson goes out to a title insurance attorney and tries to get title insurance for his client based on his legal theory. And I attached the correspondence with the title insurance attorney, to the record. And the insurance attorney said, hey, look, if your theory were correct and the property was really split and divided back in 1994, then you would need to show through the deed records how that property was actually, the Schuyler Avenue piece of the property was conveyed to your client, which of course it wasn't, because we've talked about the meets and bounds. And so there was no way for him to go get title insurance. But despite all of this, he responded to our motion to dismiss, where we said, hey, look, it looks like he's claiming that he owns this property, and he's claiming that he owns this property in his complaint. But there's this document that he filed in the public record that shows that he doesn't own it yet, and he's just trying to buy it. And we think you can take judicial notice of that, and you should really dismiss this whole thing. Mr. Robinson wrote the argument in response that no, his client wasn't claiming that he was still trying to buy the property. His client already, in fact, owned the property, and that was his claim. And that argument appears in the response to our initial motion to dismiss. And it's really black and white, because you'll recall we made all those arguments about, hey, this less and accept provision. We made all the law school arguments about the less and accept provision. And Mr. Robinson's response to that was, you don't have to consider any of that, because we're not saying that he needs to buy this property in the future. We're saying that he already owns this property, which we all know now to be false. In fact, they've made a judicial admission that he didn't own the property in their second amendment to the declaratory judgment action. I also just want to note before, I think this is perhaps anticipating a little bit, but there's some claim that by the other side, and I can't remember if it's in response to our motion to dismiss, or excuse me, in response to our motion for fees, or in their motion for fees, that Your Honor summarily dismissed all of my clients' counterclaims, and they're taking the position that you've ruled on the merits on all of that. And I just want to point out that this is their motion to dismiss right over here, Judge, and it's only 2 pages. And so this is what they're seeking fees about. And their 2-page motion to dismiss takes the position that you'll never have to rule on the legal issues in this case, because the city gave a quitclaim deed and that made everything moot. So that's what they're seeking fees about. We'll respond to their argument when they make it, but I just want to point out that they really haven't won anything on the merits in this case. They showed up, they dragged us through 6 months of litigation based on a false claim that they owned this property. They didn't own the property. And at the end of the day, even after they had dismissed all of their substantive counts, you'll recall that they declined to dismiss their attorney's fees count, the standalone 13,611 count, Judge. They kind of required us to file a motion to dismiss to get rid of that 13,611 count. And even still, they're claiming that they need attorney's fees for pre-litigation conduct, which is not appropriate. But anyway, I guess I'm anticipating their argument. I understand Your Honor understands my position. I've been going for probably a lot longer than an hour. I thank you for the time, and I'll just reserve any counter argument if that's okay.
Okay. Thank you. Ms. Jett?
So Your Honor, between Ms. Bryant, Mr. Christie, and myself, we had discussed that I would probably cover the issues as to why Mr. Jones should be entitled to a claim of fees, and that they would argue on kind of collectively everyone's behalf as to why Mr. Jones and Mr. Robinson and his firm should not be liable for fees to Ms. Cummings.
Okay.
So I don't know if that impacts who you would like to hear from first.
It does. Right now, I'm calling on someone to respond to Mr. Howard regarding Ms. Cummings' claimed entitlement to attorney's fees.
Okay.
So is it going to be Mr. Christie or Ms. Bryant? Well, Ms.
Carolina.
Bryant, you're muted.
I tell you what, why don't I go first? Because mercifully, I will be brief. Just for the record, I'm John Christie on behalf of Mr. Robinson's law firm. And just very briefly, Judge, despite having been treated nearly 50 pages of briefing by the defendant and 2 volumes of exhibits, each of which is the size of a phone book, nothing can change the fact that the defendant was not a prevailing party. And defendant's motion against both Mr. Jones and Mr. Robinson's firm turns 915-14 on its head, because 915-14 relates to litigation conduct. And I would say 80% of what I heard Mr. Howard say relates to everything happened before the case was filed, and that smacks more of a 51-781 case, malicious litigation. And there's no 51-781 claim. We're talking about 915-14. My experience in the past has been that a 915-14 claim is usually filed by the prevailing party in a case. In this case, the defendant is seeking his fees, and it didn't prevail, as I'll go into very briefly, any issues in the case. So I'm a bit of a loss to understand even why the defendant is filing the 915-14 motion to distill the facts, the essential facts, which undermine the defendant's request. It begins, of course, with all the pre-litigation conduct that Mr. Howard referred to spurring any reasonable solution which was proposed, but it continues when the litigation was filed and there are 24 affirmative defenses in a case which, in my opinion, is not very complicated, and the issues themselves are not particularly complicated. Now, I haven't been involved in all the litigation naturally. I've come at the 11th hour, but still, in looking at the pleadings in the case, it doesn't seem to me that this was a particularly complicated case, especially considering the fact that the defendant outspent the plaintiff 2-1. But we have the 24 affirmative defenses. We have the voluminous discovery that was propounded by the defendant in contrast to none that was defended by the plaintiff. As I read the pleadings, the defendant opposed about everything the plaintiffs wanted to do, other than the motion to dismiss counterclaim, ironically enough, to which they did not even respond. And I might also add that they took no action, have not challenged the deed that the city delivered either. They didn't prevail on their counterclaim, which claims ownership of the abandoned right-of-way. So I don't see how they get fees on that whatsoever. They didn't dismiss their counterclaim even when they learned that the city had delivered the deed, abandoning the right-of-way. There ought to be no fees for that. And they didn't even dismiss, excuse me, voluntarily when the motion to dismiss was filed and made the court rule on that particular motion. So I don't see how they are a prevailing party of any sort, either on the complaint or the counterclaim, and I don't see how they're entitled to any fees on those items.
Mr. Christie,
They also don't
Mr.
rebut.
Christie, Mr. Christie, let me ask you a question. So I understand your position generally, right? That it's not as if I granted a motion to dismiss or that I granted a summary judgment or some sort of final judgment. But I mean, you'd have to, it feels like the posture of this case was somewhat unique all along, including its ultimate resolution.
Mhm.
And given that Mr. Jones and Mr. Robinson started from the position that they owned the property and ultimately had to acknowledge that they gained ownership of the property, how is that not essentially Ms. Cummings prevailing on her position that Mr. Jones didn't own the property and therefore wasn't entitled to the relief that he was seeking, even if procedurally there's not an order that says Ms. Cummings wins?
Well, two things I'll say to that, Judge, and I'll get ahead of myself in my presentation. One is, if there was no reasonable or justiciable basis for Mr. Jones's position, why was it necessary for them to file a counterclaim for declaratory judgment? What was the uncertainty? I mean, the filing of the declaratory judgment counterclaim is an admission that there is uncertainty in their minds as to who owns the property and who has what rights, because she wanted to establish her rights to ownership, a prescriptive right to ownership, and she didn't get that. She didn't get what she sought in the counterclaim. So I would suggest to you that she's not a prevailing party, and she didn't get any relief on the relief that she sought in the counterclaim. Now, I would also add that this motion, there's some doubt about the sincerity of the motion. When you look at the time entries, and I looked at all the time entries that were filed, there was a time entry on October 2024. Give me a second here. I will get it precisely here. In the invoice that is dated, invoice date 12/30/2024, there is a time entry on October 23, 2024, quote, work on fees motion, close quote, 2 hours. Now, the motion dismissed in this case wasn't resolved until January of 2025, yet here we have a time entry in October where they're already planning on what on getting fees in this case and spending 2 hours researching.
Well, I don't think it was a secret that Ms. Cummings intended to pursue fees. I also will note that I think Mr. Jones was always threatening to pursue fees against Ms. Cummings throughout the course of the litigation. So I don't know that that was a secret in terms of everybody's intention.
Well, if you want compensation for something that you know you're not even entitled to, no one knew how this litigation was going to end. And they're seeking fees for work they didn't even know whether it would be necessary or not. Because everything, and I'll get to this at the end, everything's lumped together in their fees. Nothing's separated out by claims, motion dismiss, or and so forth. It's just one number, $74,000 in change. But as I said earlier, the counterclaim to me is very significant because they want to argue that everything that Jones was saying had no basis whatsoever. Yet they have to file a counterclaim because they don't know whether they have a right to the property. So I think that negates any assertion that Jones's position lacked any legal merit whatsoever. Then briefly, on the issue of fees. And whether if we even get to that point, I just wanted to point out to the court that the affidavit that was submitted does not give any testimony or evidence on the reasonableness of the legal rates that were charged in the Atlanta legal market based on the expertise and experience of the lawyers involved. It talks about the gross amount of fees, and it talks about what's necessary. It says these are the bills, this is the work we did, but it doesn't say the rates themselves are reasonable in the Atlanta legal market based on the expertise and experience of the lawyers. And I think that's a critical element that has to be in testimony when proving attorney's fees.
Well, two questions about that, Mr. Christie. One is, I believe at the beginning of this hearing, we discussed the fact that we would separate out issues associated with the actual dollar amount of any judgment. But two, can't lawyers state in their place the type of evidence you're talking about is not being included in any already filed affidavit or briefing?
My understanding was the 915-14 generally requires an evidentiary hearing. I had understood the parties had waived it and agreed to proceed on the papers. And the papers that are in evidence right now is missing that essential element. And I said earlier, I said, Judge, I wasn't going to, I mean, I've got a lot more to say about the legal fees, but I was just going to deal with just several high level issues. Again, all the fees are lumped together. There's no breakout of any of the fees. I think that precludes any award of fees in the case. So I think there's a deficiency in the evidence, even if we were to get to the point of having the court were to consider awarding legal fees. I don't think it can based on the record that it has in front of it. But Judge, I think in summary, at least the position of the Robinson firm and Mr. Robinson is that it looks like the defendant was attempting to assert title to this right of way and preventing development. There's no rebuttal of the evidence or the testimony that's been presented that her goal was to prevent development of this right of way, and also that she wasn't paying the legal fees and that she was having her legal work done on a pro bono basis. There's been no rebuttal that I'm aware of those facts. So our position is that it's the defendant who unnecessarily complicated this case and increased the expenses for herself and everyone, evidenced by the fact that she spent twice as much money as the plaintiff did in this case, and that temerity of asking for attorney's fees when she didn't prevail on anything is just unreasonable. And then it's the plaintiff, frankly, Mr. Jones, who was caused to spend more money than he otherwise would have. And as I understand the fees, and Ms. Jett will get into it, the fees that are being requested are simply the fees for the work that was necessary in dealing with and responding to all of the issues that the defendant raised in terms of discovery and other issues, including her unsuccessful motion to dismiss.
One more question. So the original petition, we went through a few forms. There was an amended petition, which I believe was the operative one. It was filed in July of 2024. And as late as July of 2024, obviously you've referenced this point about a declaratory judgment action from both sides where, in the petition, the amended petition, Mr. Jones is expressing uncertainty about who owns the property. But as late as July, in count 2, paragraph 37 of the amended petition, he was asserting that he owned the abandoned Schuyler property. which,
Your Honor, would it be
Yes,
all
ma'am.
right if I jumped in to address some of the arguments as it relates to the claims of ownership,
sure.
if I may? And I'm sorry to interrupt. I think I heard your question and I got ahead of myself, but as I understand it, you are wanting some rebuttal on the question about what the intent of the petitioner and his attorney was with respect to claims of ownership to the property. Is that right?
Yes.
Okay. And I've addressed some of this in my response, and I'd like to just kind of like go through the timeline a little bit from a title standpoint, because I think it's helpful, and I'll be really quick, I promise. So as we know, and as we've discussed, the property is in question, this abandoned Schuyler Avenue alleyway exists between two other parcels of land that Mr. Jones owned at one time. This ordinance is passed in 1994. The abandonment ordinance was changed over time, and I can talk about the history of that a little bit, because it used to be the rule that the city just abandoned property and it did go to Centerline and nobody had to pay anything. They made iterations, and you can see them on Unicode or other sources, and then we have this version that we're existing with today, which says that it's a two-step process to abandon property. One is the city has to pass an ordinance that addresses the property in question, which we know happened. The second step is parties have to go through the process of having the property appraised, and that's so that the city of Atlanta could get money for these abandonments. And so that's what was at play here. It's a two-step process. One, the city says, yes, we're going to abandon these properties. That happened. Step two is we need to know who the parties are who are entitled to make claims to that property based on what we know Georgia law is, which is the Donald versus Azar decision. Property gets split to the center line. Only the adjoining landowners have claims to that property. Are you following me so far?
Mhm.
So in 2003, when Mr. Jones deeds the property out, he reserves the right to make this claim to the property under this ordinance. It's in his deed, and it's in the deed that Ms. Cummings took title to. She took title. Yes, there's a meets and bounds description there, but then it says right underneath it, subject to restrictions of record. This was a restriction of record. This restriction traveled through title until the time that Ms. Cummings had the property, and that's why she didn't have a right to herself exercise the process that Mr. Jones was trying to go
Right,
through.
but that's actually not, one, my question, and two, not really the focus of at least this side of the motion, which is
So if
even
I
if
could
everything
finish.
you've said is completely accurate, right? And I'm sure you're probably all aware that Ms. Bryant does a great deal of special master work for me in the quiet title space. So, even if everything that you've said is accurate, and I have no reason to question, your knowledge of the law in this area, Mr. Jones still didn't own the property.
here's where I'm gonna get to that.
He arguably had an equitable right to claim it,
Okay,
which
but
ultimately did.
okay, so then the second part of the process is you have to make payment to the city of Atlanta. Okay, so what do we have in the record? We have a letter from Mr. Robinson that's attached to my motion. We have the purchase and sale agreement first. Let's look at that. Okay, the alleged purchase and sale agreement, which is really just an agreement to follow the governing ordinance. Okay, and that I'm going to rely on the exhibit that it's exhibit 12 that opposing counsel made reference to. Okay, and paragraph E talks about how you make payment, and it says that the only way you can make payment is by wiring funds, and you can only wire those funds when we give you the wiring instructions. No funds will be required until wiring instructions are issued to the petitioner. That's what it says. Okay, so then we have a situation where we know that Mr. Jones has a legal right to exercise the ability to claim this property because he reserved it in his deed. And so he starts contacting the city, and the city, all the evidence that we saw are non-lawyers making claim, loosely throwing around the word own, doesn't own, buy, doesn't buy. And what really is happening is they're trying to figure out how to follow the ordinance and the two-step process that I'm discussing. Step one, making sure that this is a party that's eligible to exercise these rights. Step two, making payment. Because of the passage of time, because of the city's own internal dysfunction, I don't know, they wouldn't release these wiring instructions to Mr. Jones. And we have the letter on July 25th, 2023 from John Robinson. And I'll point you, that's attached to my motion. It's Exhibit 1 to Exhibit A. I have to find a better way to do that, but that's always how we do it. Exhibit 1 to Exhibit A. So second page, Mr. Robinson says, on behalf of Mr. Jones, we are hereby requesting performance by the city of its agreement. And we do hereby tender the agreed upon price of $110,000. So the use of the word tender is important because that's a legally significant act. It's not just saying, it's saying I stand ready and able and I've got the money. And if you don't accept it, you're waiving your rights to that money. You are preventing me from completing the act that we've all agreed that I'm allowed to do. And that's what happened here. And I cite to the law in my motion. I'm going to just pull it up. There are two big decisions that kind of govern this concept, but it's well understood in real estate law that, I mean, this happens all the time at closings, for instance, where the seller fails to perform. What does the buyer do? They show up at a closing, they wire the funds to the closing attorney's account, and they have tendered payment. They have performed under the contract, and the law recognizes their rights when that happens. And that's exactly what was going on here. So page 10 of my motion. Sorry, Your Honor, that's page 8 of my motion. I cite to the law about tender. And the law in Georgia is that he who rejects a perfect tender waives that tender. John Robinson made a perfect tender when he sent that letter, when he said, I stand ready to deliver the $110,000. That was a sum of money that the parties had agreed upon. And the city's refusal to issue the wiring instructions was a waiver of that tender. And therefore, Scott Jones had an appropriate legal reason to say that he was the owner of the property when he filed this lawsuit, which I'll state initially was filed as a declaratory judgment.
Well, and
Was
that was
amended-
actually, thank you, Ms. Bryan, because that was actually going to be one of the questions I asked, right?
And it was amended as a quiet title, but there's no way to sue the city of Atlanta and any other parties as a declaratory judgment.
My question isn't as to the quiet title, but because I understand why once Kelco gets involved and everything else, I understand why that happened. The original claim, and Mr. Howard raises this as part of his argument as to the motivation, is that you could have filed this as a declaratory judgment saying, I'm confused. The city of Atlanta is making everything complicated, even though I've tried to tender and functionally probably am the owner, but it's unclear about, this less than accept and all that stuff. All of that could have been filed as a declaratory judgment action. But Mr. Jones and Mr. Robinson take the added step of filing it an ejectment, saying, we're not confused. We own the property and you've encroached.
Well, I think the case was styled as a petition. Hold on, I had it up.
It was definitely a petition for declaratory judgment as it was styled,
I think it was,
but it
and
contained
other
an ejectment
counts.
count. Yes.
And it had an ejectment count, which is if you're successful on your declaratory judgment, then you have standing to eject Miss Cummings. I mean, it's not in dispute that she had a fence that was encroaching in a shed that was on the property. And also that these items were unreasonably so, I will say, causing heartburn for the city of Atlanta in terms of how they were comporting themselves with Mr. Jones. I would like to add a little bit of color about that since opposing counsel has also. During the life of this litigation, the City of Atlanta Law Department had changed, and it's now Patrice Perkins, who's an extremely seasoned and knowledgeable real estate attorney. She's the former president of the Georgia section of the real estate.
I'm familiar. I think I was just
and-
at a Board of Governors meeting where she was given a Lifetime Achievement Award. I'm
Absolutely.
familiar.
She is, a fantastic real estate attorney. I am certain that she took over the law department, took one look at this and said, wait a minute, what are we doing? Which is why within 2 months of the city being added and served.
Well, this is argument and I'll accept Ms. Bryan's representation.
You also
We'll
made
move on.
that suddenly the deed was signed very quickly. And I'll add, the city of Atlanta, the agreed upon price was $110,000. And I am sure that the city of Atlanta understood that they had technically waived that tender, which is why they actually accepted $104,000 and not $110,000. They actually took slightly less in consideration of expenses that Mr. Jones had incurred going through all this. So I think, and I've said this in my motion, I would like to give opposing counsel the benefit of the doubt and state that this is like a misunderstanding, because if you understood the position of Mr. Jones, where he reserved the right to make this claim to the property, then he goes through all the steps he has to do, and Miss Cummings is unwilling to do it voluntarily. He offers her money, she's not willing to do it. He goes to the city. The city's putting up roadblocks saying, you've got to get these documents signed. Fine, I'll try to get them signed. He goes through all those steps. You have no choice but to file a declaratory judgment, which he did initially, narrowly filed as a, give me relief. I have uncertainty as to my legal relations. And if I'm successful, I need to remove these items, frankly, because the city had sort of demanded that. And then it's amended and all of that happens. But as soon as the city is added and reasonable minds take a look at the title history and the rest of it, it's very quickly resolved. The city signs the quitclaim deed. End of story. I suspect that there was some misunderstanding about the import of a tender. I suspect there was some misunderstanding about, but I also suspect, frankly, that there was some intent, and Ms. Jett can get into this, to just block a developer and not want development next to where you live. And I'm empathetic to those arguments as a human being, but I don't think that they were legally reasonable. And I think that they motivated a lot of what happened in this case. And the voluminous nature of what's occurred in this case, from this argument to everything before it. I don't want to take any more time, and I know that Ms. Jett still has to argue, and I know maybe Mr. Christie wants to say more about the appropriateness of how the motion is styled in terms of the lump sum, in terms of the lack of itemization for specific alleged bad acts and what attorney fees amount to what, and whether that specifically was reserved, I'm a little bit unclear about, but I think some of that argument should be heard. But I'll reserve argument if the court needs more from me for now.
No, I think here's what I'm concerned about. I'm concerned about a sort of reverse engineering by a skilled and capable property attorney such as yourself, Ms. Bryant, that takes the I own this property representation that was made in pleadings and motions, et cetera. Granted, there was clearly a reliance on this argument about the less than accept, and I may be calling it the wrong thing, but ultimately the discussion was really around this idea that he was that he had an equitable interest, right? A right to claim ownership to this property, but there really wasn't any dispute that he didn't own the property. And yet, how do I reconcile, even if everything you're saying is legally accurate?
So, I think property law can be a little tough. It's like the bundle of sticks, I definitely think Mr. Jones had some sticks that he was hanging on to by virtue of the reservation language in the 2003 deed. And I think that the city, having signed an agreement agreeing that he could exercise those rights under the abandonment statute when he tendered payment, gave him some additional sticks, and he actually did tender payment, and Mr. Robinson used the word tender in the letter that he sent before he filed the suit. And so I think that, did he have every single bundle in the stick? No. Did lay people throw around terms like buy and own with probably not a lot of thought to what it meant, especially in the context of what we're talking about today?
Mr. Robinson's not a layperson.
No, but he had, I think I truly believe it is a valid legal argument. If you've tendered payment and the other party is not giving you wiring instructions, which they're required to do per your agreement, and they're not accepting the payment, and you have a legal right to exercise those rights because of the reservation in your deed, that is a waiver of tender, and that there's Georgia law that would support that you were the owner of the property once you had completed that act, which he did.
And Your Honor, just briefly, this happens all the time in tax sale cases. All the time, where a person has a right to redeem property and the owner of the tax deed won't accept the money. The way the law works on that is that once the tax deed purchaser rejects tender or doesn't provide the payment amount, but tender is offered and rejected, that's it. The tender's occurred and the ownership has changed hands. It usually takes court to declare that. But it is, he actually, arguably, I think he had a good faith claim that he owned the property when he tendered, and they did not give him the wiring instructions to send the money. So he was legally the owner of the property at that time. It needed a court case to determine it because
the title records didn't reflect it. But yes, yeah. And
the record didn't reflect it. Anyway.
Well, and I said it before and I'll say it again. The same thing happens in regular closings when you have a non-complying seller where the buyer will actually tender payment. They will bring forth funds to the closing to demonstrate that they have actually completed what they needed to do per the agreement. It was the same thing at play here. And I think that was the basis for the claims that they were the owner of the property.
Thank you, Ms. Bryant. I appreciate
Your
that.
Honor, can I make one quick point? And I'm not getting into the other motion quick, but just in support, nobody has mentioned this yet, so I wanted to just bring it up.
Sure.
Since you are, have expressed some concern about the original petition making an unequivocal statement of ownership.
And the amended petition.
And
And
in
the
the
amended
amended petition, but that's what I wanted to mention. In paragraph 35 of the amended petition, the plaintiff makes an alternative argument that in the alternative, plaintiff seeks a declaration that by virtue of his express reservation in his June 2003 warranty deed to Second Avenue Development, Inc., that the abandonment portion of Schuyler Avenue abutting 1085 Avondale Avenue, he remains the sole private party entitled to complete any remaining steps to receive a quitclaim deed to that portion of the avenue. So I think so Mr. Robinson and Mr. Jones were being attentive to your concerns that a blanket statement of ownership may not fly with you. So that is why they very explicitly, I wasn't involved back in July of last year, but I would assume that the inclusion of that paragraph was meant to directly relate to the concern about this. And of course, as we all know, amendments of pleadings relate back to the beginning of the action. So I think that by virtue of the inclusion of paragraph 35 in the amended complaint, that directly addressed the concerns that you're raising.
Thank you, Ms. Jett. I appreciate that. Okay. So where does that leave us, folks? We have been going for the better part of an hour and 40 minutes. Let me start with this. But other than issues associated with fees, like the amount of fees, if the court is inclined to award them, do Mr. Christie, Ms. Jett, Ms. Bryant, do you feel that you've made the arguments you want to make on the issue of Ms. Cummings' claimed entitlement to attorney's fees, so that I can let Mr. Howard have the last word and then we'll transition into whatever we're going to do next?
I would just add one additional thing, Your Honor, and that is that I think that the way that they styled the action initially as a declaratory judgment was accurate as to Ms. Cummings, because see, she was still claiming that she had an ownership interest or a right to this property as well, and the city was blocking or not providing the wiring instructions and not completing the process because they were concerned about Ms. Cummings' claim. So in order for the plaintiff in this matter to move forward, they had to file this as a declaratory judgment action and have her right to buy this property or to be on this property adjudicated before they felt like they could get anything from the city. So even if there was a claim in the petition that they own the property that maybe was questionable, which I disagree with because of the tender, the reality is that they filed the action still correctly. It was still a justiciable claim. In other words, even if they didn't own the property, they still had a right to get a declaratory judgment about whether or not they needed her to sign off with the city before they could complete their process with the city. And that's why it was filed the way it was filed. So whether or not the court thinks that the petitioner owned the property or not, the case shouldn't turn on that. What it turns on is the fact that Ms. Cummings still felt that she had a right to block them from completing the process with the city. And because of that, the original declaratory judgment aspect of this was 100% justified. And yes, the ejectment part of it was a piggyback on it. Once the process was completed, the idea was that she needed to get her stuff off of it because it wasn't hers anyway. But that shouldn't justify $74,000 of attorney fees against Mr. Robinson or his client.
Okay.
Okay.
Thank you.
You're welcome.
Is it a correct legal statement is it correct to say that Mr. Jones, in theory, could always have purchased the portion of his property or the portion of the abandoned Schuyler right-of-way that adjoined, I think is it 1097 that he still owned, and that the only buy-in he needed from Ms. Cummings was to purchase under the abandonment statute if the less than accept provision was not effective, or whether if it did or didn't exist. I know it did, but whether it, was effective and everybody understood that it existed. The only portion that he needed some approval from Ms. Cummings for was that quarter of it that adjoined 1085. Is that right?
That
I
is
think we all
correct.
agree that's correct.
That is correct, but I think it was blocking the whole thing. That's the problem. He needed the whole thing, and I think it was blocking the whole thing. Nonetheless, whatever, he still claimed he had a right to buy it.
Well, that's right, because I mean, I think at some point, Mr. Howard presented alternative appraisals that were for just other smaller portions of the property.
Right.
The intent was to buy the whole thing. The original appraisal was done of the whole thing. Roadblocks presented themselves, et cetera. I don't know the extent of how much it was divided up in terms of appraisals, but John's right. They needed to buy the whole thing. But
I understood that he needed to buy the whole thing. I
Yeah.
guess my question was just that I was inquiring about his ability to buy half and then litigate about the other half. And it sounds like that was a possibility, maybe not a practical one in terms of what he was trying to accomplish legally, but a possibility given that ultimately there was an appraisal done for that subdivided quarter. So.
But that doesn't change.
there was no agreement from the city necessarily. I don't
Right,
know that
but-
it went any further than that.
But that doesn't change the fact that he retained a right to buy her portion of it, and her presence on it and her refusal to deal with him and sign off with the city caused a problem for his ability to buy that portion of it, which caused this litigation, and which required them to file a declaratory judgment as to her rights and his rights vis-a-vis that property, so that it could be then presented to the city and said, hey, look, she doesn't have any rights. You see, we've got this order. And now you can complete the sale that you're not doing because you're worried about her signing off on it. And I think that's the evidence of the case. And that's why this was a judiciable case, regardless of whether he's right about owning the property. I mean, that's a legal argument that nobody ever really got to, the tender and all that. But even without that, he had a right to file the case, which I think blows up any argument for attorney fees in this case.
Okay. Mr. Howard, your response, sir?
Thank you, Judge. I want to try and address them in order, so I'll address Mr. Christie's arguments and I'll try and be brief. He said that we were not a prevailing party on any aspect of this case. That's just not correct. In response to our initial motion to dismiss, Your Honor agreed with us and ruled that the City of Atlanta was a necessary party to this case and ordered Mr. Jones to bring them into the litigation. So we prevailed on that. And then at the end of the case, we ended up having to file a motion to dismiss Mr. Jones's standalone claim for attorney's fees, and we prevailed on that as well. So that's actually two issues that we prevailed on in this case, in addition to what Your Honor noted about ultimately establishing that the property was not owned at the time of the filing of the case. There was an argument made about how this really is more in the nature of a 51-780 motion for attorney's fees rather than a 9-15-14 motion for attorney's fees, because I spent a lot of time talking in my argument about pre-litigation communications and conduct. To be clear, our position is not that the pre-litigation conduct is the problem. Our position is that the pre-litigation conduct demonstrates that at the time the litigation was filed, Mr. Jones knew that he did not own the property. In fact, contemporaneous communications indicate that Mr. Jones knew that he did not own the property while the litigation was pending. So really, we are moving for attorney's fees for having to defend the litigation to the extent that he's making a false claim of ownership on the property. So
Mr. Howard, let me ask you a question. By your analysis and sort of what I've heard from Mr. Bryant and Mr. Ayub, if Mr. Jones, when he initiated this action against Ms. Cummings, had named City of Atlanta and said, I've tendered, I own the property, why aren't you giving it to me? Would that have been in your estimation a more good faith justiciable position for Mr. Jones to have taken in this litigation?
It certainly would have been a more accurate reflection of what happened. If he had sued the City of Atlanta and said, I've tendered, why are you not transferring the property to me? And he had not sued Ms. Cummings, he could have potentially ended up with the same result. I don't know. But picking on Ms. Cummings, because he had to wait 60 days from when he served his ante litem letter, and hoping that he wouldn't have to sue the city of Atlanta because he was hoping that maybe she would just bend to what he's asking and sign their certificate of intent rather than hire a lawyer. That's what happened here. Now, I understand that they claim that there's a declaratory judgment count, and there is, but there's nothing in there about him being confused about his rights as to the property or expressing any uncertainty. In fact, the declaratory judgment count is 2 paragraphs, and he just says he's seeking a declaratory judgment that he is the sole and exclusive owner of Schuyler Avenue. So what he's seeking, if he doesn't allege that he was confused about his rights, which he doesn't, really he's just asking for an advisory opinion. And then he gets down to the ejectment where he alleges affirmatively that he already owns it. So he's really not alleging any uncertainty at all. And the ejectment count, as you mentioned, it's not only that he claims that he has an equitable right to acquire, he claims that he is the owner of the property, and that he claims that he has legal and equitable title, which is what he said a variety of times under oath. So you can't have legal title without the deed. I mean, he just doesn't have it. So the allegation is false. And then he, of course, sues her for attorney's fees, as if she had some sort of obligation to agree with him that she needed to waive her right to the purchase of the property. So she was unnecessarily harassed, I think, in response to your honor's question, which is that if he had said, hey, look, the arrangement we have with the city of Atlanta is this is a copy of the contract. And if he attached it to his pleading, which he didn't do, and we sure would like to complete it, and we would like to tender the money, and we'd like for the city of Atlanta to give us a quitclaim deed. If he'd said all of those things, then he would have subjected himself to a motion to dismiss the ejectment claim against Ms. Cummings, and he couldn't sue the city of Atlanta. I mean, his own lawyers have said in their internal correspondence to him and their strategic communications that are attached to our motion that when they serve the ante litem notice, they have to wait 60 days before they can sue the city of Atlanta. So they wanted to sue her immediately in hopes that they could get a quick resolution, and then maybe they'd never have to sue the city. And that's what Mr. Robinson told me when we met for lunch, is that we would, hopefully we'll never have to sue the city, but we're willing to if we have to. So I think he's trying to avoid suing the city of Atlanta. I guess ironically, we forced him to sue the city of Atlanta, and then his client got exactly what his client wanted when he did it. Like, probably he should have thanked me, but that's not what happened. So I want to quickly breeze through the other points that Mr. Christie made. He said we filed 24 affirmative defenses, and he said, and he complained that we filed a declaratory judgment action. Your Honor probably will recall from our briefing and from the attachments that we did have some uncertainty because I was trying to figure out from talking to Mr. Robinson before we answered the complaint whether or not his client actually had received a quitclaim deed for the property. I could not get a straight answer from Mr. Robinson concerning whether his client actually owned the property or not. I sent him a couple of emails before we responded and said, hey, you sued her for ejectment, but you'd have to own the property. Here's a copy of the contract that you filed in your affidavit in the real property records. It says that there has to be a quitclaim deed or you don't own it. He emailed me back and forth 2 or 3 times and was very cagey about whether specifically his client owned this property. And ultimately, the best I could get from him is our legal position is that he doesn't need a quitclaim deed. And so he really did leave us in a position where, until we did some discovery, we didn't know what their rights were, other than the contract was in the real property records. I know Ms. Bryant called it the alleged purchase and sale agreement, but it's only alleged because Mr. Jones attached it to an affidavit that was prepared by Mr. Robinson and filed it for all the world to see and claimed that it was a true and correct copy of his contract with the city of Atlanta. So I don't know how you get more confirmed than that. But so we did have some uncertainty, and that's why we filed a declaratory judgment action. But the fact is that he didn't own the property, which we all found out. He says that the defendant outspent the plaintiff 2-1. Judge, if you look at what Mr. Robinson's fees affidavit actually says, he's not claiming all of their attorney's fees against us. I think, in fact, the parties had roughly similar attorney's fees throughout this matter. It's just that they carved out a bunch of it. I don't think they carved out enough, but we'll save that issue for another day, because Mr. Robinson is seeking to impose fees against Ms. Cummings for time he spent defending against Kellum's motion to intervene, which is obviously inappropriate. So, we have some things to say about that. He said on October 24th, I have an entry in my billing records about preparation of a fees motion, which casts doubt on the sincerity of the motion. I'll note that that is right at or after the time when the quitclaim deed became, I believe the quitclaim deed became public matter. Let's see here. In late September, they filed their amendment to their declaratory judgment action, September 27th, 2004. And in that amendment to their declaratory judgment action, Judge, paragraph D, because it is legally impossible to adversely possess property owned by any governmental entity, defendant Cummings has no right, title, or interest in any part of the abandoned Schuyler Avenue. So they admit in this amendment on the 27th that they got a quitclaim deed, and until they got it, the government owned the property, which obviously disproves their prior allegation. So that's why I would have started working on a fees motion at that time. We now had an admission in judicio that they knew they didn't own the property, or that they chose to claim it legally. And I'll just say, in response to much of what Ms. Bryant said, I think this admission in judicio really cuts off her argument at the knees, because once you admit that you didn't own the property, you can't go back and argue afterwards, well, if Mr. Howard really understood real estate law, he would understand that we did own the property. No, they made this admission that they didn't own the property, and they're stuck with it. They never withdrew it. So it's there, and they know that they did this. So that kind of confirms what I've been saying. Mr. Christie said that he said that I made no representation whatsoever in my fees affidavit as to the reasonability of my attorney's fees for the market. And I'll just point out that I know Mr. Christie is kind of new to the case, but in paragraph 8 of my affidavit, I said the attached invoices reflect the actual fees and costs incurred by Ms. Cummings that were necessary to defend against the false claims brought against her by Mr. Jones. The work performed and total expense incurred for the legal services rendered in conjunction with this case are reasonable in light of the nature and complexity of the work involved. So if the hours and the total cost are reasonable, I would suggest that means that the hourly rate was reasonable. My hourly rate is fairly low. I suspect that if we compared my hourly rate to the people on this call, I'm guessing that it's lower than Mr. Christie, lower than Mr. Ayub. I'm guessing it's going to be lower than Ms. Bryant, but we'll see. It's not that much for this case. So it is a very reasonable hourly rate, and I think I spent a reasonable amount of time trying to figure out what was going on here and deal with it. Mr. Christie said that we filed an unsuccessful motion to dismiss. I don't know how Your Honor feels about this personally, but you will recall that at the end of the hearing on our initial motion to dismiss, you decided to take it under advisement, Judge. And so you never really ruled on it. You didn't grant it, you didn't deny it. They filed an amended pleading, and we filed a renewed motion to dismiss. And that was actually that wasn't ruled on either. So neither of our motions to dismiss were ever ruled on in this case. And of course it became moot. And so it wasn't necessary for you to do so, but it's not like we filed motions to dismiss that you said this is frivolous and you denied them. They were taken under advisement and not ruled upon. Let's see here. Ms. Bryant talked about tender a good bit. And Judge, I think a perfect tender would require that all of the aspects of the contract were complied with. And at the time that the city was rejecting the tender, they were taking the position that Mr. Jones and Mr. Robinson didn't have the right to purchase the portion of the property that was adjacent to Ms. Cummings' house or Ms. Cummings' property. And so what they were saying was that the contract itself requires you to have the right to do this, and we disagree with your position about your less than accept provision in the deed. And so the city was saying, when you get her to sign the certificate of intent, you will have complied, and then we'll be good to go. Then we'll give you wiring instructions. So I would submit that while he tendered the right amount of money for the contract, it's not a perfect tender, because at least according to the city and what the city believed that the contract meant at the time, not all the conditions precedent had been complied with. So that's not a perfect tender. And we would dispute that argument on that basis. There was a question about standing and Mr. Jones's standing to file the ejectment action. Ms. Bryant, I believe, argued that if he had prevailed on his declaratory judgment claim, then he would have had standing to seek ejectment. Well, Georgia law is fairly straightforward that standing is determined at the time that the complaint is filed. So he doesn't have standing the minute the complaint is filed, and he doesn't have standing at any point later in the litigation unless he waits until the standing develops and then he files the claim. So he didn't have standing to pursue ejectment at the time that he filed it because he didn't own the property. And so I disagree. I disagree that he's allowed to file that claim, and the alternative probably should have been dismissed. And if the litigation worked out to be, we have a declaratory judgment action because we're not certain what our rights are, Ms. Cummings could have made a very different decision at that point about whether or not she wanted to spend a lot of time defending, because declaratory judgment actions don't inherently carry with them awards of attorney's fees. She had to defend because of the ejectment claim. She had to defend because he's suing her for attorney's fees because of his false ejectment claim. Ms. Bryant talked about the bundle of sticks. I think I noted this in my brief, but she hasn't cited a single case suggesting that the stick that she is referring to in this case is actually a stick that can be retained. And I think that's important because what she's saying is that by carving out the right to purchase the adjacent property, that a stick that a party can either sell or retain can burden the adjacent landholder's land. It's a position that if they wanted to establish it, they would have needed to litigate this case pretty far down the road. I think it would have been a novel question in Georgia law, but they don't have a single bundle of sticks case cited in their brief. She says we all learned this in law school, but I did not learn in law school that you could sell a parcel of property to somebody other than your neighbor, and in that deed, you could alter the available market of purchasers for your neighbor's property in the future. So I think that's not really an open and shut question like she suggests. And then there was an argument from Mr. Ayub about tax deeds. I think there's a specific code about that. I haven't cited any law whatsoever about a less than accept provision that works in the way that they say that this less than accept provision works. They haven't cited a single case where there was a less than accept provision that carved out the ability to buy an adjacent abandonment. They don't have, I went and looked, I looked at throughout Georgia case law, I found about 14 less than accept cases. Every single one of them has to do with carving out the metes and bounds of the particular piece of property or the rights that you're conveying on the particular piece of property that you're selling. Not a single one of them has anything to do with an issue like this case. So I don't think this notion of that the bundle of sticks theory was going to carry the day for them was going to prevail, but they certainly didn't cite any law that would create a justiciable question on that point, for your honor.
Well, but ultimately, to Mr. Christie's point, right? I mean, because of the procedural way that this case ended up being resolved, not only, to Mr. Christie's point, did the court not affirmatively determine that Mr. Jones never owned the property, or at the time that he alleged that he did, the court also, no one ever adjudicated that the less than accept provision gave him that interest. It's simply that the city of Atlanta ultimately decided to accept it and moved on. And Ms. Cummings at some point.
Maybe that's what the city of Atlanta accepted. I mean, maybe that is what they decided, but they didn't do any of this in front of the court, right? So all we know for sure is that the city of Atlanta sold him a quitclaim deed for the property. We know that before it happened, J.D. Kellum sent me a fairly aggressive email stating that he was good buddies with the attorney's husband, Doug, and that he was going to sit with her at a dinner and he was going to negotiate a resolution. So we don't know what happened other than J.D. Kellum got together with Miss Perkins Hooker and Doug and work something out. Maybe that's what he said he was going to do anyway. Mr. Ayub argued that, well, I think I'm going to go back. Probably just going back over, but for certain, you're right, Judge. The court did not determine any of these issues on the merits. I think the only thing that seems fairly clear from the state of the evidence that was produced by Mr. Robinson and by Mr. Jones is that not only did Mr. Jones not own the property at the time he filed the verified petition in this case claiming that he did, but that all of his correspondence behind the scenes suggested that he understood that he didn't own the property and that he was desperately trying to acquire it. And our argument is he put the burden to Ms. Cummings to defend the litigation based upon a false claim of ownership. And he made the false claim of ownership so that he could tack on a claim for attorney's fees in hopes that he could get a signed certificate of intent and not have to sue the city of Atlanta. That's why we think this is so egregious.
Thank you, Mr. Howard. So it is 20 till 6. Tomorrow is a holiday. I've got all the time in the world, but the question is, what do the parties want to do in terms of the remaining issue of Mr. Jones's motion for attorney's fees? If it's something that the parties are willing to continue going and believe that we can be efficient about it, I'm willing to continue doing that. I'm also willing to say that it is, right before a holiday and we should all go home and, enjoy our families and go do whatever it is we do. The only concern I do have is I can probably find a way to squeeze this in, the continuation of it next week. But I don't know what parties, because it is the week after a holiday, if people have leaves, or what parties have going. Miss Jett, I'm sorry, who did, Miss Jett, you were going to be handling Mr. Jones's motion, correct?
Yes, Your Honor. And as I'm sure you understand, the issues are very interrelated between the two. So I am confident that I can be efficient and get through argument in 15, no more than 20 minutes.
Okay.
So
And
I'm
I've
willing
already
to.
got my Peachtree Road Race number, so we're good.
Good.
I text you a picture of my ID. We're all
I
good.
mean, I don't want to, keep anybody here who really needs to go, especially if there's childcare or anything like that. But I'm also willing to rip the Band-Aid and just be efficient and get it done.
Mr.
It
Howard?
was so much fun. I wish it would go on all night.
I've already texted my husband and asked if what he's gonna make me for dinner. So he
Same.
answered that he was making me ice cream for dinner. So I don't really know what I'm coming home to.
Everyone's abandoned me, so it's chips and dip. So
Well, she at least left you her computer. Come on, Mr.
that's
Christie.
true. She left me her computer. That's right. I'm a
Mr.
hospital.
Howard, what are your thoughts, sir?
I'll take Mr. Christie to dinner, and my main concern is for Mr. Roberts. If our court reporter is good to go, then I'm good to go. But if not, then I wouldn't want to overburden him. I'm just concerned that if we have to come back, there's going to be, additional cost and inefficiency.
Agree. Mr. Roberts, are you good? You're muted, sir.
Yep, I'm good to continue as well.
Okay. Thank you, Mr. Roberts. Ms. Jett, if you'll go ahead with your motion.
Okay. So Your Honor, as you know, we've gone through all of the steps here. There was a contract that was entered into between the city and Mr. Jones in May of 2022 that allowed for the sale of this property back. And then in September, the city came back and, said, yes, this meets all of our requirements, fair market values accepted, et cetera, et cetera. And there is nothing in any of those documents that requires any additional sign off by any adjacent owner. That the city had at that time accepted Mr. Jones' argument that based on that reservation of rights and that deed to Second Avenue development, that he had the right to claim the entire width of the roadway. So things were moving along, and we had gotten to the point to basically just waiting on the deed to drop. And then someone in the city of Atlanta's law department said, hey, you know what? We're going to now require, even though we've already got our contract, we're going to now add an additional requirement that you have to get this consent form signed by Ms. Cummings saying that she doesn't object to the purchase of, to Mr. Jones' purchase of this property. Mr. Jones did not then, does not now believe that that was something that the city could really require of him. But, bureaucratic process, you put a hoop in front of that man, he's going to at least try to jump through it. So begrudgingly, he approached Miss Cummings and went to her home. They both live in the same neighborhood, of course. but went to her home in May of 2023 to explain everything that was going on. They stood out on her porch, talked about it. They were looking at the, alleyway area. Then, she asked, I've got a son in high school. I'm planning on moving whenever he graduates. Can you just hold off? I really don't want any development by me. So I wish I could, but I have been working on this for literally years. This is my retirement nest egg. I need to move. I mean, I'll, don't want to inconvenience you, but I really need, to move on with this. At which point the conversation shifted. She got real angry, rushed him off the property, indicated, but for the fact that she didn't own a gun, whatever. So he left. But before leaving, did tell her, contact the city. You can verify everything that I'm telling you, about the existence of this contract, et cetera, et cetera. And because of the veiled threat, did not go back again to talk to her in person. But a couple of weeks later, hoping that she had in fact talked to the city and that tempers had died down, he had reached out and said, again, I don't want to inconvenience you, but I need this to move forward according to the city now. I'm willing to compensate you for any expenses that, you incur in moving the property. That didn't go anywhere. He was trying with the city saying, why do we really need this? Y'all have already entered into the contract, but the city was just not cooperating. So then he hires John Robinson to help get him over the finish line. And that's whenever John Robinson wrote the letter that you're aware of, Your Honor, that offered even additional money to Ms. Cummings to help persuade her to cooperate. That likewise did not go anywhere. Mr. Robinson, as Ms. Bryant mentioned, the July 25th, he was in constant communication with the city trying to get this done. But finally, on July 25th of 2023, he made that unconditional offer of tender of the purchase price. Gave the city some chance to respond positively to that. That also did not go anywhere. So finally, in the spring of 2024, he sent the ante-litem notice that we have discussed and filed this declaratory judgment action to confirm that, in fact, Ms. Cummings does not have any right, title, or claim to this property. In hopes, yes, Mr. Howard is right that this would, if nothing else, this would cause her to realize the, merits of his claims and to hopefully then cooperate. Instead, what happened is Mr. Howard came in, represented her. He filed an answer with, as Mr. Christie indicated, dozens of affirmative defenses, a rather vaguely worded counterclaim, asserting both a claim for a declaratory judgment to declare that less and accept provision in the Second Avenue development deed as ineffective, and claiming some sort of ownership of some undefined amount of Schuyler Avenue by adverse possession. And then, of course, he filed his contemporaneously a motion to dismiss, arguing all of those same things about the less and accept provisions that were raised in his affirmative defenses. Very quickly thereafter, Mr. Robinson reached out to Mr. Howard. As he referenced, they went to lunch to try to talk this out person to person. And two takeaways from that lunch meeting, Mr. Howard indicated that he was representing Ms. Cummings pro bono because their sons are friends, teammates on, it's in Mr. Robinson's affidavit.
Well, I didn't say that, but go on.
Okay, go ahead, Ms. Jett.
Fine. I haven't seen any rebutting evidence or affidavit disputing that. And that Ms. Cummings was not going to concede to this lawsuit because she did not want the development coming next to her house, which is, of course, consistent with the same thing Ms. Cummings told Mr. Jones on her front porch. So there we go. And every action that Ms. Cummings or on behalf of Ms. Cummings through Mr. Howard has been consistent with that position. They have sought to stall and object to every single position that Mr. Jones has taken in this litigation. I'll talk about the merits of the two broad categories of the legal positions that they have taken. And that would be, one, their claim of adverse possession in this property. They claim in their counterclaims that the property is owned by the city of Atlanta, but yet also she had acquired property that doesn't define the metes and bounds of what portion of the property, but that she had acquired some property through adverse possession. Those two things, as we all know, are incompatible. You cannot adversely possess against the government no matter how long of a time you have been in possession. Now, I understand that Mr. Howard has sort of retroactively sought to re-engineer their claim, oh, well, that was just in the alternative. If Mr. Jones actually did own it, then we're not claiming that you can adversely possess against the government. They know that. But instead, we're claiming that if, in fact, Mr. Jones did own the property, then she's adversely possessed against against him. And a couple of notes on that. One, that's not what their pleadings say, but, to be generous or benefit of the doubt, if that was what they intended to argue, that adverse possession count under any claim cannot stand. As we know, there are two forms of adverse possession in Georgia. There's outright prescriptive title, which is possession under 20 years. No one's claiming that they have that, and in fact, they don't have that. But then Georgia law does allow you to shorten that 20-year rule down to a 7-year rule under adverse possession under color of title. But in order to do that, to the color of title portion of that means you have some written instrument, usually a deed, but anything that can be considered a muniment of title to allow you to get that from that 20-year rule to the 7-year rule. It's, some sort of written evidence that, although ineffective, nonetheless gives you a right or some sort of colorable title to enter that land. There is no question that the only document that Miss Cummings had was the deed into her property, which describes only her lot. That deed does not, and nobody has argued that it does, purport to describe any portion of Schuyler Avenue. So there is no set of facts or circumstances under which she could claim adverse possession as to any portion of Schuyler Avenue. So that's one area.
Except that, just playing devil's advocate for a moment, right? By Mr. Jones, the logic of Mr. Jones' entire lawsuit is that the property was abandoned by the city in 1994 and became the property of the adjoining landowners. And there's no reason for Mr. Jones's argument for the less than accept provision unless he believed that that adjoining property attached to 1085. And so, that's not a problem that we have to solve. It's just that I don't think it's quite as simple as you would characterize it. And I don't know that it, at least to my way of thinking, is as unreasonable as Mr. Jones is attempting to characterize it, for her to say, I have had this, I've owned the property since 2003 and the fence has been where it is. And no one has said anything to me about it. And so I adversely possess, at least from a pleadings perspective, might not have survived a summary judgment, might not have survived even a motion to dismiss, but meriting bad faith, lack of any justiciable basis, I'm not sure.
Well, that's certainly not how they pled it in any of their arguments. So that is a very...
Just as Mr. Jones didn't plead that he owned the property because he had tendered it and therefore he effectively owned it. He just said he owned it.
Yeah, until his amended petition, like 3 months later. Sure.
Right.
That's one category of items. The others is the attacks on the less than accept provision in that deed, which I'll read it real quickly because I don't think it has been read into the records today. It says, less and accept any right, claim, or inchoate interest of any kind to buy, own, possess, or access Schuyler Avenue Southeast that may arise by virtue of the ownership of the premises demised herein. So there's a couple of, there are at least 11 arguments that they make seeking to undermine and argue as to the validity of that less than accept provision. One is Ms. Cummings had no actual knowledge of the provision. Well, that is irrelevant. It is recorded in the deed records. She therefore has constructive notice. Actual notice is not required by the law and is irrelevant. It is in her own chain of title. So the notice thing goes nowhere.
Ms.
The
Jen,
rest, go
forgive
ahead.
me for interrupting you, but let me ask a much more basic question.
Sure.
To Mr. Christie's point a moment ago, right? The court never adjudicated that Mr. Jones was or was not the owner. And based on that, Mr. Christie argues that Ms. Cummings isn't a prevailing party for purposes of her motion. Similarly, the court never actually adjudicated the less than accept provision. And given that, does that mean that Mr. Jones's motion fails because he wasn't a prevailing party for purposes of proving or prevailing on the argument that that less than accept provision made him the equitable owner of the abandoned Schuyler property?
Excellent question. And you've kind of anticipated what my argument was going to be. So we'll just get straight to that. You'll notice that once that deed came from the city on September 25th of last year, that was premised on the new city attorney comes in and says, just as Ms. Bryant said, guys, they're right. That less than accept provision is what gives them the right. We're going to go ahead and issue the deed. Now, if Ms. Cummings and Mr. Howard truly disagreed with that conclusion, they would have then entered an argument saying the deed from the city to Mr. Jones is invalid. They didn't have the right to convey to that because Mr. Jones was not an abutting owner, and Ms. Cummings has filed a notice or signed the intent saying that she intends to acquire on it. We're going to hold the city's feet to the fire and we're going to demand our interest. Instead, as Mr. Howard has already said today, the issuance of that deed rendered it moot. They agreed that the city had the right. Nobody has challenged the deed from the city. They would have to challenge the deed from the city if they truly believed that that less than accept provision was not a reasonable basis for Mr. Jones to close that deal with the city. Additionally, I'm sorry, did that satisfactorily answer your question? Okay. The other issues on the less than accept provision all relate to this convoluted argument that they are misrepresenting that this reservation of rights in the less than accept provision is somehow a restrictive covenant. And I know that nobody here is as much of a, dirt nerd as me and Ms. Bryant and Mr. Ayub. So just if you'll give me a couple minutes to entertain that distinction. A reservation of some sort of right is when you are conveying property to somebody, but holding back something of yourself. That can be a variety of ways. Mr. Howard said, we had to point to a specific case law that says that you can do it a specific way. The law is littered with examples of this. I can give you my property and reserve for myself a life estate. I can give you my property and reserve for myself mineral rights, air rights, water rights. I can give you my property or convey to you my property and reserve for myself an easement for access and egress to get to the family burial plot that's in the land right behind this lot. I can give you this property and reserve for myself the right to claim the adjacent property. There are dozens of kinds of reservations of rights. Conversely, what a restrictive covenant is I give you this property and I am imposing on you a restriction on your ability to use that property. So in the metro area, we most commonly see that in like HOA covenants. You know, you're buying this property, but it is subject to the use restriction that you can't paint your house purple. You can't have chickens in the backyard. You have to have a minimum square footage or maximum square footage for what you can buy, for what you can do on that property. So all of those arguments that it doesn't run against the run with the land, the worrying about your honor's reluctance to hear the term rule against perpetuities, that it expires because it's been more than 20 years. All of those things have absolutely no basis in law, because what this is a reservation of right. It is not a restrictive covenant. And Your Honor is right. You did not have to rule on that. And why didn't you have to rule on that? Is because the city consummated the transaction that was already in place between itself and Mr. Jones. And then once the city decided we were right, Ms. Cummings decided, okay, the jig is up. And in fact, what happened right after, and this is also in Mr. Robinson's affidavit, the moment we got the deed from the city of Atlanta, he reached out to Mr. Howard and said, you know, basically, the jig is up. The deed has been issued. Can we all just take our toys and go home now? There is nothing left to fight over. And even though there was no legal argument that no, we're going to proceed on because we think we still have some basis to argue against that, they said, no, all right, the issue's moot, but no, we're not going to withdraw our counterclaims. So that is why then I had to file the motion to dismiss their counterclaims, which Your Honor ultimately granted. Yes, you granted them as moot, but they were asked to withdraw them to begin with. So everything from that September 25th on, this case only continued because Ms. Cummings refused to withdraw her counterclaims. So if Your Honor is looking at, drawing a line in the sand, of course, so I'm not going to talk about actual dollar amounts, but I do want to mention that Mr. Robinson and I were very careful and meticulous in going through our time entries, identifying only those things that dealt with responding to Ms. Cummings' claims. Unlike their own motion, we did not make a bulk lump sum award request. We tried to be very targeted as to just those things. And in both of our affidavits, we have pointed out the individual time entries. If Your Honor thinks, as does apparently Mr. Howard, that the issue of ownership only became moot as of September 25th, 2024, then Your Honor could certainly draw a line in the time entries and only include those that accrued after then. I don't think that that's appropriate, because I do think that they have advanced several legal positions that have no merit. I think that they have been consistent both in their behavior and their expressed words to Mr. Jones and Mr. Robinson, that their sole intent in advancing this litigation is to stop the development from her, next to Ms. Cummings' property. But absent that, I certainly think that September 25th, 2024 date is highly significant. And there was absolutely zero reason for the continuance of the litigation. After that, you'll see that we had voluntarily dismissed our own title claims once we got the deed, and all we're seeking was a dismissal of theirs, and they absolutely refused and would not do it until Your Honor entered the order on that issue. So absent any potential rebuttal or questions from Your Honor, I promise to be brief.
Thank you, Ms. Jett. Mr. Howard, your response? You're muted. It wouldn't be a Zoom hearing if I didn't have to say that at least once, sometimes to myself. So.
Thank you, Judge. Although the record will reflect that I did not start speaking before I clicked the button.
That is true. You held up a hand.
Okay. All right. The January 14, 2025 order, that was the order that Your Honor entered dismissing the counterclaims as moot, doesn't require an award of attorney's fees. This is our first argument, our response to their motion. If Your Honor will take a look at their motion for attorney's fees, their specific statement to the court, their entire argument was a 2-page motion, was that whether or not Jones's reservation was effective, and then they dropped the footnote, Jones still contends that it was. The city's delivery of a quitclaim deed for the disputed property in conjunction with Cummings' position that renders that issue moot as a determination of whether or not the less than accept reservation is effective is mooted by the city's delivery of a deed. So they told you in this motion that they filed on October 25th, 2024, that you didn't need to consider the effect of their legal position any further. And Your Honor will probably remember that following their filing this motion, the attorney for Mr. Kellum started to enter his appearance, and he sent an email to the court stating that there had been a settlement between Mr. Kellum and Mr. Jones that was going to result in the dismissal of all claims, and that was going to result in Mr. Jones conveying all of this property, including 1097 and Schuyler Avenue, to Mr. Kellum or his company, Kelco. And Your Honor responded in that email chain and asked whether that was going to end all litigation, whether that made the entire case over. All this happened before my response deadline to this motion, but Mr. Kellum's attorney responded to Your Honor and said, well, from our perspective, it will, but maybe the parties will have something to say about attorney's fees. And I responded something similarly. And what I said to Your Honor in my response was, if the settlement happens the way that Mr. Kellum and his attorney are representing it, we intend to withdraw our counterclaim about the effectiveness of the less than accept provision because this case is effectively moot. So I wrote to you that I don't think you will have to rule on the motion to dismiss our counterclaims, and that we would be withdrawing our motion to dismiss as well because we would be content to just go on about our business, but we're reserving our rights as against the city of Atlanta and as to attorney's fees against Mr. Jones. That was the email correspondence leading up to our response deadline. Looking at this, I did not think that it merited spending time and legal fees drafting a response on behalf of Ms. Cummings because I wanted to see whether that settlement was going to actually go forward. And in fact, it did. It just took a while. And so this allegation that all of the litigation after the mootness issue happened was because of Ms. Cummings' refusal to withdraw her counterclaims is just not correct. I'm not sure that Ms. Jett was counsel at that time or not. I don't recall. But certainly we took the position at that time that we'll just wait and see if his settlement goes through, and then it's all moot at that point. Now, Ms. Cummings has certainly said in a variety, I think, of pleadings, at least 2, dropped a footnote that says that all of this is without prejudice to her ability to sue the city of Atlanta for damages because it hasn't followed its own procedures. She does not think, and I do not think, that the city of Atlanta got this right, but it's unnecessary to fight that in this case. I mean, the allegations of this case as pled were that Mr. Jones owned the property and she should get off of his property. Well, he didn't own it at the time that the case started. And then, of course, because of the settlement agreement where he was conveying the property to Kelco, he wasn't going to own it when the case ended either. He was at no point really, except for a very minuscule amount of time, ever going to actually have possession of the property. So this claim that the order dismissing as moot are counterclaims, if you look at their motion, they state very pointedly that Your Honor found that none of our claims were justiciable. And that's not at all what happened. So if you look at the basis of their motion, they're claiming that this motion to dismiss for mootness and the order that Your Honor entered was some sort of ruling on the merits. That's what they claim in their briefing. And we've responded to that in our briefing because obviously this was just this is a mootness issue, and it was one that we didn't respond to for the reasons that I just articulated. I think I've included a copy of those emails in the record. If not, Your Honor certainly has them and can double check what I said. But we didn't just ignore their motion, and we don't agree with their position that they always had the right to acquire this property. We certainly don't agree with it. We think that at least one of our less than accept arguments was probably correct, but we just never got down to it. I do not agree with the position that we had an obligation in this case to oppose the quitclaim deed. In fact, we didn't have a claim pending against the city of Atlanta. I think the city of Atlanta had been dismissed or was being dismissed from the case anyway. Certainly, we could have cross-claimed, I suppose, against the city of Atlanta, but we're not required to. Plaintiff is not required to bring all of their claims in the same action, and we're certainly not required to sue the city of Atlanta in this case. So I don't buy the argument that because we didn't object to the quitclaim deed that we've somehow waived our right to do so in the future. In fact, we may well be preparing a litigation against the city of Atlanta right now. So that's a possibility. Their second argument is that, and I think it's been covered pretty well, the court's never ruled on the less than accept provision. And I see many of you are kind of looking like my speech is garbled. Are you having trouble hearing me, or is this?
I'm not having any trouble. I can't vouch for anybody else, but I'm hearing you loud and clear.
You're good.
I had some garbling from Miss Jet, so I wondered if my connection was good, but good. Okay. Mr. Ayub, it's your body language that made me wonder if I wasn't speaking loud enough.
You're fine. My wife sent me an email and I had to look at it real quick. Sorry, I apologize.
No problem. Mr. Christie's point about there was never a ruling on the merits, I think actually does apply in this circumstance. I bet Your Honor is going to ask me at some point, why is our motion different from their motion? Would you like me to answer that question, or do you want me to wait?
Go ahead, sir.
What's that?
I said, go ahead, sir.
The difference is because their actions resulted in the mooting of all of this, right? And because it's the issue of did he own the property is so simple to resolve. The issue of did he own the property is resolved if you want a linchpin that you can hang your hat on by the allegation in their amendment to their declaratory judgment action that they filed on September 27th, where he admitted that until he got the quitclaim deed, the city of Atlanta owned the property. If he admits that, then he is admitting that the allegation initially that he owned the property when he filed the lawsuit was not correct. And so he's admitted in judicio that his position was invalid and that he dragged us through the tort claim and the fees claim without basis. So that's the distinction in my mind, among others that we've discussed today. The city law department, by the way, agreed with us. In order to survive their motion, we have to have some factual support and some legal support for our positions. In response to their motion, we've cited legal support for our positions about the various less than accept arguments that we made. But in terms of factual support, I'll just direct Your Honor's attention to Cummings Exhibit 30. That is an email from the city law department, Ashley Vanderland, where she says to Mr. Jones, this is a lawyer, so it's not just random people throwing around words like own, by the way, it's the city law department. To the extent your client seeks to purchase the second half, which the other abutting owner is entitled to purchase by law, the city requires the attached certificate of intent to be completed by that owner. Unfortunately, the deed you have provided is not sufficient to stand in place of a completed certificate of intent. So that's what the city law department told to Mr. Jones. And the city, Bashan Mann at the city of Atlanta, when Mr. Robinson emailed or sent a letter to Ms. Cummings and said that his client already owned the property, she turned around and sent that to Bashan Mann at the city of Atlanta and said, hey, I know you're not a lawyer, but do you agree with this? And he sent her paperwork that she would need to petition for ownership of that half of the property, meaning clearly the city of Atlanta at all levels did not agree with Mr. Jones, and they were telling Ms. Cummings at the time that they didn't agree with his position that he already owned the property. So I think we have factual and legal support for our defense. And it would be kind of, if Your Honor wanted to award attorney's fees to them on this, the law would require you to make findings of fact and conclusions of law. They would have to articulate, specifically what it was that we did. that was wrong. And I think you would have to probably go through and analyze a bunch of legal questions that did not ultimately get analyzed in this case because they mooted it all by withdrawing their claims, voluntarily before there was an opportunity to rule on any of that. So it would be kind of silly to come and ask Your Honor to write a lengthy order explaining these novel legal concepts now when they had an opportunity to do it in the litigation and they didn't do it. They're talking about the adverse possession claim. I don't think any of these lawyers were at the original hearing on our motion to dismiss. My recollection of that hearing, and there was no court reporter, was that the argument was made by Mr. Havorka, and Mr. Blazer attended because Mr. Robinson was out of town. And my recollection is that Mr. Havorka actually stuck us with a gotcha about the adverse possession claim, and the gotcha was you can't adversely possess from the city of Atlanta, haha. And my recollection is that at that time we clarified that that's fine. We agree you can't adversely possess from the city of Atlanta, but if his position that he's now stating is correct, that he owns the property, we could adversely possess from him. That was the extent of it, I believe, at that hearing. That is my best recollection of how that went down. Maybe Your Honor remembers, maybe you don't. But from that point forward, at no point did anybody file a motion to dismiss or a motion for summary judgment on Ms. Cummings' adverse possession claim. And so, the question becomes, could she have adversely possessed the property? The answer is yes. If in 1994 it was abandoned by the city and owned by private parties, her fence had been on the property for in excess of 7 years. And she obtained property under color of title, and the color of title is the quitclaim deed to her and her husband, late husband, John Botts, said that she was obtaining 1085 and all appurtenances there too. We've cited some law, to Your Honor, about how an appurtenance could be a fence. It could be the area within a fence. A garden within a fence could be an appurtenance. So there is some language in their deed. Now, I believe in Ms. Jett's brief in her motion for attorney's fees, she takes us to task, claiming that Ms. Cummings didn't even possess the property for the full 7 years, and so therefore we should doubly be sanctioned. What Ms. Jett, I guess, did not appreciate was that Ms. Cummings' last name was Botts, her husband, John Botts. She lives at the house currently with her son, Zachary Botts. And so Ms. Jett made about a 2-page argument about when Ms. Cummings obtained the property and it not being long enough to be 7 years, not appreciating that Ms. Cummings has actually held the property for much longer than that. It's just that her name changed when she was divorced from her late husband, John Botts, and then he claimed the property to her. So she's been in possession of it the whole time. So we've had to respond to that in our responsive papers and correct that record. I think the adverse possession claim, as you mentioned, was a viable claim as pled, because in the alternative, if he was right that he owned the property already, she could have possessed it from him. Plaintiff's discretionary motion under 915-14B should be denied because I believe I believe we belabored the point in some ways, but it's our position that it's Mr. Jones who has harassed the plaintiff by suing her in ejection, even though he didn't own the property. And then in terms of the arguments about the amount of attorney's fees, I certainly appreciate Ms. Jett's concession that if Your Honor agrees with the mootness point, that a line could be drawn in the sand at September 25th or whatever that date was. But I also believe that after that date, they're asking for attorney's fees that involve defense work against Kelco rather than against Cummings. So I think that that's a point that would need to be explored. But as I suggested, I think that Ms. Jett and Mr. Christie and myself could get together and talk about those if Your Honor was inclined to award fees one way or another. I think probably reasonable heads could sort that out and not drag Your Honor through additional argument. So I would stand on the response of our briefing, but the oh, I'm sorry, one final point. Ms. Jett made a point about 2 points. One about constructive notice. And certainly I agree. I don't think anybody could disagree that you're charged with constructive notice of what's in the deed records. We're not taking issue with that point, but Ms. Jett's position assumes that Ms. Cummings would read that lesson accept provision and agree that it's going to be binding on her, right? So if she doesn't agree that it's a provision that could run with the land, or if she doesn't agree that it's a provision that could bind her, or if she doesn't agree that it's a provision that could work legally at all, if she's charged with notice of it, that's fine. But it doesn't mean that just because it's there, it works. So that's one point. A second point was we keep talking about the tender, but I just note that after the tender, I believe, or the alleged tender, which we don't agree, was a perfect tender, but after the alleged tender, I think the timeline is correct that Mr. Robinson and Mr. Jones went back and then started negotiating for purchase of half of the property. I would need to double check that timeline, but I think it's a point that needs to be double checked, because if they're at that point talking about only buying half, it undermines their position that they own the whole somewhat. I object to all of the comments about what allegedly I said to Mr. Robinson at a lunch that none of these other attorneys attended. He may believe that that's what I said, but I don't think he understands the points that I was making, or I think he might be misconstruing them. I did not say that I was representing Ms. Cummings pro bono. What I told him was that I had decided to represent Ms. Cummings because her son and my son are good friends, and that she needs help, and I agreed to assist her. Certainly, she is on the hook for her legal fees and has been paying towards them. So I want to make that point very clear. She's not getting pro bono representation here.
Well, it doesn't matter, right? I mean, none of that is a relevant consideration. Go ahead. I'm just going to move on from that because I don't know that it doesn't play into my consideration.
Fair enough. Thank you, Judge. I did not sit there and tell Mr. Robinson that Ms. Cummings' only intent was to stop development next to her house. We had a lengthy discussion, but I'm not going to go into all of the ifs, ands, or buts about potential settlements. That is not a fair characterization of what we discussed when we sat down that day. So I don't.
I've heard a lot about the parties' motives and intent on both sides, and I question whether any of it matters, because if the position you took was a factually and legally justifiable position, then I don't really care what your motivation was. Your motivation only becomes concerning to the court, or on a 915-14 motion, something that the court would consider if the position that you were taking was not legally and factually justified. Then the court is concerned about why that position was taken.
Certainly, and I appreciate it. And Your Honor will probably have dealt with this issue more times than we have, and you will be familiar with all the case law that says just because you're wrong doesn't mean that the other side gets an award of fees, right? You can be wrong about something as long as you have a good faith basis for your position, and there is no award of fees. And we both said that in our briefing, which I think is true as far as it goes. But here, in this case, and I guess my last word is the only thing that nobody had a good faith basis to claim was that at the time that the litigation was filed, that Mr. Jones in fact owned Schuyler Avenue and had a right to eject Ms. Cummings from it, and had a right to his attorney's fees for the ejectment.
Thank you, Mr. Howard.
Ms.
Jett, or whoever, it's your motion, so you technically get the last word.
No, that's fine, Your Honor. I don't know that I have much to say that has not already been covered today. So the only thing that I will reiterate is, well, for one thing, I do want to acknowledge what Mr. Howard said. I did not realize until reading his response to our motion about the thing with the name change for Ms. Cummings, and that actually her period of possession was longer. And so that was just something that was raised before I got here, and I tried to very thoroughly digest everything that had come before me, but that was apparently a detail that had escaped my knowledge. But I would point out to Your Honor and Mr. Howard that is irrelevant. That there's no argument that prior deed would give her the 20 years that are necessary for an adverse possession claim. She still has to travel under the under color of title 7-year rule. And while those two deeds may have added up to more than 7 years, it doesn't satisfy the color of title standard. It has to be included in the metes and bounds of the legal description of her deed. And there is no dispute that the metes and bounds of her deed in no way described any portion of Schuyler Avenue. So that's the only clarification point that I wanted to make, unless Your Honor has any questions for me.
Nope. I think that all of you
Your Honor.
fine lawyers. Yes, Miss Bryant. I was just about to
So-
say y'all all beaten this horse to death, but apparently we haven't yet.
Okay,
Go ahead, Miss
so
Bryant.
I took advantage of some of the extra time to just pull 2 quick case sites that I thought would be helpful to the court, if I may.
Thank you.
One is on reservations and exceptions in title. It's 198 Georgia 95. And then a second decision on, what happens when somebody refuses a perfect tender. And that is 300 Georgia 91. The name of the first decision, if it's helpful, is on reservations exceptions is Atkinson. Excuse me. That's not the name of the case. The case is
Don't worry
Mendenhall
about it.
versus
I
Oaks
would
Claw.
rather you focus your time on telling me what you believe they stand for, because I
Okay,
got
yeah.
the citations
It
and I'll see
explains,
what they.
well, I didn't know if you wanted to hear any more from me, so I thought if I would start with that. But the reservation and that case just gives a nice quick, this is what happens when you reserve something in a deed, since there was the allegation that that hadn't been substantiated by way of case law. I think that case will be instructive, and it just gives an explanation of what they do when you put those in deeds. And then I think this was a perfect tender. The agreement, which I hesitated to call a purchase and sale agreement because it's not styled as that. It's called petitioner's election to purchase abandoned right of way, and it's only signed by Mr. Jones. It's not signed by the city of Atlanta. And so that was the reason for the distinction. It's still enforceable, but it sort of demonstrates that he had the sole right to purchase that property. It was for him to elect to exercise that right. But it requires that payment be made by wire, and that wire can only be made when the wiring instructions are released from the city to the party. And Mr. Robinson's letter from July 25th, 2023 says, I stand here ready to tender payment. Please send me your wiring instructions. That was in 2023. The wiring instructions were never delivered. Instead, other things were asked for, but I just wanted to clarify that point on tender. And I'm sorry if I've taken more time or been repetitive, but.
No, I don't think that y'all have been repetitive. I appreciate everyone's contribution to the conversation. I am going to, I'm going to take this under advisement. It will be my goal to let the parties know what my ruling is going to be sometime in the month of July is the best I can promise, because there are judges conferences and vacations and all sorts of other fun things that will be more fun than figuring out the answer to this, to these dueling motions. Beyond that, I am most of you have appeared in front of me as a matter of your regular practice. And for those of you, just to be clear on what my typical practice is what I typically will do is say, hey, this is what I've decided, and I'm going to send the parties an email essentially that says, this is going to be my ruling. And typically we'll request the prevailing party to send me a draft order that I can then edit. We will go from there. I don't always do that. Sometimes I've asked for dueling orders from the parties and then take it from there. But my goal will be to get you an answer as soon as I can, and then get you an actual order that the parties can take action on as soon thereafter as I practically can. Any questions, or does anybody need anything from me beyond this issue that I'm taking under advisement, starting with Mr. Howard?
Judge, can you hear me okay?
Yes.
It's garbled on my end a little bit.
Okay.
Okay. I just like an opportunity to respond to the 2 citations. Obviously can't do that today, so I'll send Your Honor something next week. I'd rather do it by email if that's all right, rather than on the record.
I would prefer that it be informal and also not a whole big long tome in terms of just, Ms. Bryant, I think, is pointing out, I took Ms. Bryant's reference to those cases as here's what the law generally is on this topic. And if you have concerns about how that applies here, then yes, you can send me an email and let me know if you have concerns about those two cases. I don't think that's an unreasonable request.
Thank you, Judge.
Anything else, Mr. Howard?
I don't believe so, Judge. Thank you for your time.
Thank you, Ms. Jett.
No, Your Honor, I'm good. Thank you for your time this afternoon.
Mr. Christie,
Judge, you have the patience of Job. I have nothing further.
Mr. Ayub,
My name means Job, actually. I'm good.
Ms. Bryant.
Nothing further, Your Honor.
Okay,
Happy
thank you
4th of
all.
July.
Thank you all. You too.